Good morning, everyone. Welcome to the Board of Pharmacy meeting. Thanks for joining. Today is December the 10th, and we will go ahead and get started. I will ask Dr. Gandhi to do a roll call. We'll revisit conflicts of interest, and then we will pick up on the agenda with the hearings 26. Dr. Gandhi?
Mr. Solari?
At your service.
Mr. Dang?
Present.
Mr. Minkus?
Here.
Mr. Leyba?
Here.
Ms. Lehan?
Present.
Ms. Walmsley?
Present.
Mr. Tong?
Here.
Mr. Goodman?
Good morning.
And Ms. Nair?
Here.
Thank you. From yesterday, we have the disclosed recusals, and we have the paperwork to correspond with those. Since yesterday, board members, I would like to give you a chance if there are any additional to come forward. We'll start with Mr. Goodman.
Sorry, I had to unmute. I don't have any conflicts.
No worries. Thank you. Mr. Dang.
I don't have any conflict.
Thank you. Mr. Solari.
Same as yesterday, just 29F.
Thank you. Ms. Lehan.
Same as yesterday.
Mr. Tong.
I have none. Thank you.
Ms. Snare.
None.
Ms. Walmsley.
Nothing additional.
And I have nothing additional as well. Okay, thank you. Okay, consent agenda 26, cases recommended for approval of state's motion to vacate hearing and deem. This is the time for the board to consider consent agenda 26 through 26A through 26E. Faith and Christensen, board case number 20-0285. Jesse Nevada Lucas, board case number 20-0235. Claudia Gallego, board case number 20-0197. Michelle Marie Cloud, board case number 20-0257. Karina Marie Motzkin, board case number 20-0299. Does any respondent or attorney or board member want to pull any case from the consent agenda for further consideration? Okay, thank you. Will the state's attorneys please introduce themselves?
Seth Hargraves, Assistant Attorney General.
If you're on mute. Are there any other parties present for these matters?
Ryan Miller, case number 20-0627.
Good morning, Mr. Miller. We are not quite there yet. I do thank you for introducing yourself and good morning, but we will come back to you when it's your turn. Does it sound good?
Okay, sorry.
No worries, and I'll kind of guide you through that process when it's time.
Rachel Day here, case number 190263.
Ms. Day, the same with you. We're not on those yet. This is just for the names that I called. So if I called your name and you're in the waiting room, if you are here, you can speak up. If not, Ms. Day, we will come back to you as well, and I'll guide you through that.
Thank you.
The state has filed a motion to deem and vacate the hearing in each of these matters. In these motions, if these motions are granted, the board will have adopted the factual allegations set forth in the complaints and its findings of facts as its conclusions of law. There a motion regarding the state's motion to deem.
Mr. President, I move to adopt the recommendations. I'm sorry, I move to grant the state's motion to deem and vacate the hearing.
I'll second that, sir.
Okay, I have a motion and a second. I'll call for discussion. Having said that, roll call.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba?
Aye.
Ms. Lehan? Ms. Lehan?
Sorry, aye.
There we go. Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Okay, thank you. Board members will now deliberate on the appropriate discipline to be imposed.
Mr. President, I move to adopt the state's recommendations for discipline as set forth in the motions to deem and vacate the scheduled hearings.
Thank you, Ms. Walmsley.
And I'm happy to second that, sir.
Okay, and I have a second by Mr. Solari. Any discussion before a vote? Do I need a roll call? Thank you.
Mr. Solari,
Aye.
Mr. Day,
Aye.
Mr. Minkus,
Aye.
Mr. Leyba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Thank you. This concludes the proceedings. The board's decision will be reduced to a written orders, which will be sent to each of the respondents. Thank you. Moving to 27A, Gavin Charles Ingalls, board case number 19-0442. This is the date, the time, and the place for the matter dealing with Gavin Charles Ingalls, board case number 19-0442, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there has been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include myself, Joe Leyba, Lori Walmsley, Kristen Snare, Kevin Dang, Ruben Minkus, Mohammed Solari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect that the board members have been furnished copies of the complaint notice of hearing and all the proceedings of records. Will all parties please introduce themselves?
Seth Hargraves, Assistant Attorney General, on behalf of the state.
Can you hear Mr. Hargraves?
Not very well.
Seth, I'm not sure if you are on mute or if they just can't hear you.
It looks like he's on mute.
Quiet.
Hear me now?
It's faint.
Yeah.
How about now?
That's
There you
better.
go. Got it.
Okay. So Seth
Hargraves, Assistant Attorney General on behalf of the state.
Okay, thank you. Is Mr. Gavin Charles Ingalls present? Okay, thank you. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witness, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first.
Mr. President, we just want to clarify whether or not Mr. Ingalls is on the call somewhere. Director Gandhi had spoken with him this morning, and he did indicate he was coming. So if he's not here now, maybe we can table this and come back to it.
Dr. Gandhi is trying to get a hold of Mr. Ingalls.
I see that you joined the meeting. Whether he's joining right now, his audio is just linked up.
Okay, thank you.
Mr. Engels, are you there?
Mr. Engels, can you hear us? Mr. Engels? Looks like it's still not working. I sent you a Mr. President, we're trying option B to get them to communicate with you guys.
Should we move to Mr. Miller?
Okay, Mr. Engels, can
Hello,
you hear me?
Yes, I'm here.
Okay, here we go. You're muted, Mr. President.
Good morning, Mr. Ingles. Thank you for joining the meeting. Before we get started, I'd like you to introduce yourself, name, and for the record, please.
Yes, my name is Gavin Ingalls.
Thank you. Do you have an attorney that you'll be representing you today?
No.
Okay, I'm just going to give you a few words here and then we'll proceed. You have the right to be represented by an attorney, but the law does not provide an appointment of counsel on your behalf. If you want an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you are waiving your rights. This hearing is your opportunity to present testimony and evidence on your behalf, and if you appeal the board's decision, the record you make at this hearing today will be evidence considered by a court in determining whether the board's decision was proper. Do you understand what I have told you, and do you wish to proceed without counsel today?
Yes, I do wish to proceed today.
Thank you, Mr. Ingles. Okay, we are on to opening statements, and each party may now make an opening statement. This is a brief summary of the case you intend to be present today. Does the state wish to make an opening statement?
Yes,
Thank you. Just as a preliminary matter, we have a potential settlement proposal for the board. This case involves an issue of Mr. Engels failing to timely disclose pending criminal charges to the board within 10 days as required by ARS 32-3208. In the course of the investigation, he also failed to respond to a board subpoena. In discussion with Mr. Engels this morning, Mr. Gandhi submitted a proposal that I believe Mr. Engels is agreeable to, and that would be a consent agreement for a $250 civil penalty for the failure to disclose. We believe this could be tied to another agenda item 20E. Mr. Engels is also on the board's agenda for discussion of his renewal application. The state would propose, and Mr. Engels can indicate whether or not he's agreeable to this. But if so, we ask the board to consider offering Mr. Engels a consent agreement for a $250 civil penalty and have his renewal contingent upon signing and accepting that consent agreement and paying the civil penalty. And if he fails to do so, that his application be denied. Mr. Engels, is that something you are agreeable to?
Yes, that is something that I am agreeable to.
So the state would propose that for the board's consideration to resolve both this hearing matter as well as his renewal application.
Thank you, Mr. Hargraves. Board members, before we entertain a motion, do you have any questions or discussion? If not, I'm willing to entertain a motion.
Mr. President, I am happy to make a motion to accept the consent proposal as the consent agreement as proposed by Mr. Hargrave and Mr. Engel.
Second.
I have a motion and I have a second. Council, any clarification before a vote? Okay. Dr. Gandhi?
Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leyba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Yes.
Ms. Nair.
Aye.
Okay, thank you for your time today, Mr. Ingles. The board staff will be in contact with you on the consent agreement.
Okay, thank you.
Thank you. Agenda item 27B, Ryan Anthony Miller, board case number 20-0267. This is the date the time and the place where the matter dealing with Ryan Anthony Miller, board case number 20-0267, is scheduled to be heard by the Arizona State Board. Formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include myself, Joe Leyba, Lori Walmsley, Kristen Snare, Kevin Dang, Ruben Minkus, Mohammed Salari, Theodore Tong, Cedar Lahan, and Nick Goodman. Let the record reflect the board members have been furnished copies of the complaint, notice of hearing, and all the pleadings of record. Will the parties please introduce yourselves?
Seth Hargreaves, Assistant Attorney General on behalf of the state.
Mr. Miller?
Ryan Miller.
Good morning, Mr. Miller. Welcome to the meeting. Do you have an attorney that is representing you today, Mr. Miller?
No, I do not.
Okay. You have the right to be represented by an attorney, but the law does not provide an appointment of counsel on your behalf. If you want an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you are waiving your right. This hearing is your opportunity to present testimony and evidence on your behalf, and if you appeal the board's decision, the record you make at this hearing today will be evidence considered by a court determining whether the board's decision was proper. Do you understand what I've told you, and do you wish to proceed without counsel today?
Yes, I do.
Okay, thank you. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, and otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Each party may now a brief summary of the case and the intent to present today. Does the state wish to make an opening statement?
Yes, thank you. The issue in this matter is whether or not grounds exist to take discipline. I'm sorry, is that? Whether grounds exist to take disciplinary action against Ryan Miller, pharmacy technician who is disciplined in the state of Oregon and failed to comply with a board subpoena. Mr. Miller is a holder of pharmacy technician license in the state of Arizona. On or about June 16th, 2020, board staff discovered through the National Association of Boards of Pharmacy Clearinghouse that Mr. Miller had surrendered his Oregon technical technician license. Upon discovering that he had surrendered his license, board staff sent a complaint notice and a subpoena to him on June 17th, notifying him of the open complaint and requesting that he respond and provide written explanation of the events that led to the surrender, as well as copies of the consent agreement and any orders, that he submit those by June 30th. Mr. Miller did not respond. Thereafter, on or about July 9th, board staff followed up with an email to Mr. Miller inquiring whether he intended to respond. He subsequently responded to the email, stated he doesn't have the documents because he had turned in his license voluntarily. He also stated that the Oregon board did not believe why he was turning in his license, so they accused him of some lie that he didn't commit. In subsequent emails, he disputed he was the individual in question or that he had a license with this board, told staff to leave him alone or he would sue their ass. Basically stopped cooperating. He never provided the requested documents. Staff was able subsequently to obtain those documents directly from the state of Oregon, which showed that on or about May 31st, 2020, Mr. Miller entered into a consent order in which he agreed to surrender his technician license in Oregon. According to the terms of the order, he admitted the allegations that he had physically assaulted another employee while working as a pharmacy technician at Community Compounding Pharmacy in Lake Oswego, Oregon, on or about October 18th, 2018. That consent order constituted disciplinary action. It's the state's position that grounds exist for disciplinary action against Mr. Miller's Arizona license, as in regards to having committed unprofessional conduct, specifically having a license to practice as a pharmacy technician denied or disciplined in another jurisdiction, and failing to comply with a board subpoena. State believes that after the presentation of evidence and testimony, that grounds exist for disciplinary action in this matter. Thank you.
Thank you, Mr. Hartgraves. Mr. Miller, the opening statement is a brief summary in the case you intend to present today. Do you wish to make an opening statement?
Yes. All of this information that Mr. Hargreaves has is false because I have never been disciplined in any work situation anywhere except for this place because I was having a relationship with a whore. And that's what led up to this disagreement with my coworker. So, and I have other medical issues that my employer didn't like. And so that's why when I try to defend myself, they just think that I was berating them or something, but I was not. I was just trying to state my opinion. And I have epilepsy as well as Asperger's syndrome disorder, and all this is from these disorders I have. And reason why I didn't contribute or adhere to the subpoena in Oregon is because, as well as now I have been hesitant, is because I have epilepsy, and when put under stress like this and being harassed constantly, I'm liable to get a seizure.
Okay, thank you for your opening statement this morning, Mr. Miller. I would like to remind you that if you're not comfortable discussing patient-sensitive information, you do not have to do so. Having said that, would the state please call your witness?
Yes, the state calls Cam Gandhi.
Dr. Gandhi, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Dr. Gandhi, could you please state your name for the record and tell us where you work?
Kamlesh Gandhi, work for the Arizona State Board of Pharmacy as the executive director.
And how long have you been with the Arizona Board of Pharmacy?
I've been with the board for about a little over 5 years now.
And are you also a licensed pharmacist?
Yes, I am.
And how long have you been a licensed pharmacist? Could you just give us a brief overview of what your responsibilities are as director of the board?
Managing board of pharmacy, licenses, inspection, making sure that the professional pharmacy is practiced lawfully.
And you're on mute. We can't hear Dr. Gandhi.
I apologize. We have multiple people in a room, so we're playing mute games here. My job as the executive director of the Board of Pharmacy is to ensure that the practice of pharmacy is conducted lawfully with the state and federally.
And through your employment with the board, are you familiar with Mr. Ryan Miller?
Yes, I am.
And is he a licensed pharmacy technician with the board?
Yes, he is.
I'd ask you to take a look at what has been marked as States Exhibit 1. It is Bates page 4 of the packet of exhibits, which is located in the board book at page 3465. And can you identify that for us?
That is a document generated by the Board of Pharmacy indicating verification of someone's license.
And is that person Mr. Miller?
Yes, it is.
And according to this printout, when was he first licensed by the board?
The license was issued November 20th, 2015.
And what is the current status of that license?
Current status is open.
And what does that mean?
Open in a board of pharmacy is active to practice pharmacy as a technician in this matter.
Okay. And what is the purpose of today's hearing?
Today's purpose is to discuss the matter of Mr. Miller not responding to our subpoena.
Now, the issue before the board has to do with him being disciplined in another state. Is that correct?
That is correct, yes.
And how did that issue first come to the board's attention?
We have partnered with NABP, which is National Association Boards of Pharmacy Clearinghouse, and we have notification of an action that was taken with the Oregon Board of Pharmacy.
And looking at what has been marked as States Exhibit 2, Bates page 7 of the exhibits, located board book page 3468. Could you identify this document?
That is a document issued by NABP. It's a clearinghouse action report.
And is this an action report in regards to Mr. Miller?
Yes, it is.
And could you summarize the report for us, please?
Certainly. The description is license surrendered pursuant to and on October 18, 2018, while working as a pharmacy technician at a community compounding pharmacy in Lake Oswego. He physically assaulted another employee.
Okay. And up, it indicates an action date. What was indicated as the action date?
Action date was June for 2020.
Okay. And what action was taken in regards to his license?
The voluntary surrender of the license was taken.
Upon receiving this information, what, if anything, did board staff do in regards to this matter?
We sent Mr. Miller a letter to ask for additional information regarding what.
Okay, and looking at what's been marked as States Exhibit 3, it's Bates page 9 through 12 of the exhibit packet, which is board book pages 3470 through 3473. Could you identify these documents for us?
It was a certified letter sent to Mr. Miller dated June 17, 2020. And it looks like it was signed as received by the address that we sent it to.
And was there anything else sent with the letter?
With the letter was issued a subpoena asking for detailed description of the events that led to the surrender of the license in Oregon and any remedial corrective actions that was taken, the copy of the consent agreement, and provide current place of employment.
And what was the date of the letter and subpoena?
The letter was issued June 17, 2020. The subpoena was also dated the same time period.
And according to the subpoena, when was he requested to respond and provide the information by?
By June 30th, 2020.
And did he respond and provide the documents by that date?
No, he did not.
Okay. And when he didn't, did staff make an attempt, any additional attempt to contact Mr. Miller regarding this matter?
Our normal procedure when we don't get a response is, yes, we would reach out to the license holder after the expiration date or after the deadline.
Now, if you can take a look at what is marked as States Exhibit 4, Bates numbers 14 through 22 of the state's proposed exhibits, as well as board book pages 3475 through 3483. Could you identify these documents for us?
Certainly. That was communication between Mr. Miller and Ms. Dodge. And it looks like also Ms. Mitchell was involved in that communication as well.
Okay. And these emails were dated between July 9th, 2020 and July 10th, 2020. Is that correct?
That is correct.
Okay. I want to start out on Bates page 22, which is board book 3483, kind of work backwards. That appears to be the first email dated July 9th, 2020 from Ms. Mitchell to Mr. Miller. Could you read that email for us?
Certainly. Good morning. The Board of Pharmacy sent the attached complaint notice of subpoena to your address of record on June 17th. As of this date, we have not received a response. If you do not respond to the subpoena by the close of business, July 16th, 2020, staff will forward a complaint to the board for their consideration with an added allegation of failing to comply with a subpoena.
And jumping back 2 pages to Bates page 20, which is board book page 3483, there are 3 email responses from Mr. Miller. Is that correct?
That is correct.
And could you read those for us in order, starting with the first one at 1:13 p.m. on July 9th?
Certainly. I don't have such documentation since I turned my license in voluntarily, since I was having difficulty of obtaining any work in Oregon, not currently working now. The next email communication, never received any written or typed information either, since I have never lived in Washington State. Are you sure you have the right Ryan Miller? Third communication, since you definitely have the wrong physical address and thus email, leave me alone.
Okay. And Ms. Mitchell responded to that, did she not?
Yes, she did.
And looking at her response on the top of that page, could you read that for us?
You hold a technician license in the state of Arizona. You're required to respond to the complaint notice of subpoena. If you do not, your case will be placed on the board's consent agenda to be voted to formal hearing for revocation.
Okay. Going back to Bates page 18, board book page 3479, we have his responses to that email. Could you read those for us chronologically, starting with the 4:16 p.m. one?
Sorry, I told you I am not the Ryan Miller that has this license. If you keep bothering me, I'm going to sue your ass. Next communication. Plus, I have never worked in Arizona, so how can I have a complaint? You evidently don't believe me when I say I turned my license involuntarily to Oregon. If you knew me, I or anyone that knows me, I am 100% honest.
Going back to the page before that, Bates page 17, there is an additional email from him. Actually, 2 additional ones. Can you read those for us?
It is impossible to attend court since I don't live here, even though I voluntarily turned my Oregon license back in. Oregon Board of Pharmacy did not believe why I was turning my license back, and in so just accused me of some lie I didn't commit. Next communication, just wanted to let you know that the reason I didn't think it was me was because when I looked at the paperwork, I just looked at the name and address. When the address wasn't right, I just assumed that it was not me. I'm currently out of town With no access to a computer or printer since I'm camping, I won't be able to meet the deadline.
And that was July 10th, 2020, correct?
That is correct.
Okay. And at the top of that page, Dr. Dodge had responded to Mr. Miller at that time, correct?
Correct.
And can you just read that first paragraph?
Sure. Mr. Miller, the board subpoena was sent to the address you provided the board. This address was changed by you on November 17, 2018. In addition, you attested that your address and email were correct when you renewed on October 7, 2019. Whether or not you decide to provide the required information documentation is up to you. Regardless, this will be presented to the board at the next board meeting, along with the emails below and the additional allegations.
Did Mr. Miller follow up on any of those and provide the documentation that had been requested?
Not that I can tell.
Okay. Was board staff able to obtain that documentation by any other means?
Yes, we were.
Okay. And looking at what is marked as States Exhibit 5, this Bates page, starting on Bates page 24, Board Book 3485, could you identify these documents?
It is a consent order issued by the Oregon Board of Pharmacy.
Was the Arizona board able to obtain this directly from the Oregon board?
Yes.
Okay. And could you summarize the order for us?
It outlines what actions or what Mr. Miller has done. Mr. Miller also acknowledges that he understands what this consent order is about and has signed it.
Okay. On that page, Bates page 24, the fifth whereas paragraph, it states the licensee admits that the facts alleged in the above noted notice are true and that his conduct as admitted violated Oregon statute and rules. Is that correct?
That is correct.
And in the next whereas, it indicates that the licensee consents to the disciplinary action as set forth herein, correct?
Correct.
And what he was agreeing to is that his technician license would be surrendered, correct?
That is correct.
Going to the next page, document was signed by Mr. Miller, is that correct?
Yes, correct.
And in the paragraph above his signature, the first sentence states, I hereby acknowledge I have read and understand the above noted notice in terms of the consent order, correct?
Correct.
Going to the next page, Bates page 26, which would be board book page 3487. It's a copy of the notice from the Oregon board, correct?
That's correct.
And according to this document, the second paragraph, what were the allegations against Mr. Miller that he admitted to by signing the consent agreement?
On October 18th, 2018, while working as a pharmacist and community compounding pharmacy at Oswego, you physically assaulted another employee.
And next paragraph indicates that that conduct would be unprofessional conduct under Oregon law.
That's correct.
And as a result of this incident, information obtained by the board, this matter was set for hearing, correct?
Yes, correct.
And that's the hearing we're here for today.
That is correct.
And looking at what's been marked as State's Exhibit 6, dates pages 29 through 34, board book pages 3490 through 3495. Is this the complaint notice of hearing in this matter?
Yes, it is.
And this sets forth the allegations and possible violations alleged against Mr. Miller?
Correct.
And that is that he has been had a license to practice denied or disciplined in another state or another jurisdiction. Is that correct?
That's correct.
Committing an offense in another jurisdiction that is committed in this state would be grounds for discipline.
That's correct.
And failure to comply with the board subpoena, correct?
Correct.
From what you have reviewed, was Mr. Miller's license in another jurisdiction disciplined?
Yes, it was.
Did he comply with the board subpoena in this matter?
No, he did not.
And did Mr. Miller respond to the complaint notice of hearing?
That I couldn't answer, Mr. Hargraves.
We're looking at what's been marked as Exhibit 7, beginning on Bates page 36, board book page 3497. Could you identify this document?
Yes, it's a letter from Mr. Miller dated October 6, 2020.
And that letter is after the date of the notice of hearing was sent to him, correct?
Correct.
In addition to the letter, did he also provide copies of any documentation?
He did, yes.
And would that be the documentation that the board had previously requested and subsequently obtained from the state of Oregon?
Correct.
Based on your familiarity with the facts of this case and Mr. Miller's history with the board, do you have an opinion regarding his ability to be regulated by this board?
I do, and I feel that Mr. Miller, it was not very cooperative with the board, not compliant with the board subpoena order, and therefore may be considered as unmanageable and should not be licensed.
Mr. President, I would move to admit States Exhibits 1 through 7 into evidence.
Thank you. Acknowledged.
And State has no further questions for Dr. Gandhi.
Okay, thank you. Mr. Milner, that was the testimony of the state. You will be given a chance to do the same. Do you have any questions you would like to ask on what you just heard?
What was the question?
Do you have any questions for Mr. Hargraves or Dr. Gandhi on what you just heard?
No.
Or remarks? Okay. Board, do you have any questions? Okay. Mr. Milner, you are now given the chance to make your testimony yourself.
President, if I may, Mr. Miller has submitted email testimony for the board's consideration.
Okay, thank you. Board members, a email testimony has been submitted, and I will allow it into the case.
I'm going to ask Mr. Hargraves if he objects to it.
Mr. Hargraves, do you object to the email evidence that was entered into the case?
Well,
I would like Mr. if possible, Mr. Miller to lay a foundation for it and enter it himself.
Seth, you cut out on that. You would like, could you restate that, please?
Well, at this point, if we haven't heard from Mr. Miller that this is his proposed exhibits or that he wants it presented to the board. So I think we need clarification as to if he's actually asking for that.
Mr. Miller, did you hear that question? Are you asking that this document be allowed as your test?
You cut out there, but yes.
Okay, I'll restate it for you. You're asking that we allow this written testimony into the board material.
Yeah.
Okay. And are you saying that you would like us to read that and you do not want to make a statement? Is that what you're saying? This is the chance for you to make a statement if you would like to. If you would like to, I'll swear you in and then we'll listen to what you have to say.
Yes, I believe that the reason why I didn't adhere to any of those orders that Mr. Hargraves.
Mr. President, I'd ask that he be sworn in.
Yep, I was trying to get there. Mr. Miller, before you make your testimony, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Oh, yes.
Okay, you're free to begin.
Oh. The reason why I didn't adhere to any of those subpoenas because I know what I did at work was not my fault at Community Compounding Pharmacy, and that it was a result of having a relationship with an adulterous woman that is trying to have sex with her. And so I did everything that I could to stop that, but she kept on being aggressive and wanted to have sex with me, and I kept telling her no, and then she just I was trying to get out of her way at work, and then I took it as being physically abusive, which I never have been in my current past work experience. And I just don't think that with ASD that people will really understand me, and that they should inquire about what I have to go through, because I have trouble explaining things.
Okay, thank you. Any other comments before I ask if the state has any questions for you?
No, I don't.
Okay, thank you. State, do you wish to cross-examine the witness?
Just a couple of questions. Mr. Miller, did you sign the consent agreement with the state of Oregon?
Yes, only because I was forced to, because when they initially sent it to me, I didn't want to sign it, and I was just gonna think about it and get back to them. But then when they sent it in like June or whatever for me to sign, I just figured that they wanted me to consent to the event that happened, and not that I specifically did it.
You signed the document, correct?
Yes.
And did you respond and provide the documents to the board in response to their subpoena?
No, because like I stated at my opening statement, I was being and continue being harassed for this event, and that I did not want to have to deal with you guys, because my employer, Community Compounding Pharmacy, was being dishonest, as well as the Oregon State Board of Pharmacy. So that's why I turned my license in, because I don't want to work with any dishonest people like that.
No further questions.
Thank you. Board members, do you have any questions?
Mr. President, may I ask a question for Mr. Miller?
Yes.
Mr. Miller, why do you want to keep your Arizona license? Do you ever intend to practice here?
Yes, I might.
Can you elaborate on that?
There might be a possibility where I have to move down to be with my grandparents, which are live down there, to be their caregiver, and so to maintain some work in like part-time to make some money to help us live. That's why I want to keep it.
Thank you.
Other questions from the board members? Okay. Mr. Milner, do you rest your case in your statement?
Yes.
Okay, thank you. This concludes the evidentiary portion of the hearing. The board will now hear closing comments. The state may make a closing comment and the respondent may make a closing comment. Does the state wish to make a closing comment?
Yes.
Yes, thank you. The evidence and testimony that's been presented has established the allegations set forth in the complaint notice of hearing and has established the alleged violations of law also set forth in the complaint notice of hearing. Mr. Miller has attempted to essentially relitigate his case with Oregon. That the reasons or what he may or may not have done are simply irrelevant for these proceedings. If Mr. Miller wanted to challenge the allegations that he assaulted a coworker, his time to do that was before the Oregon board. He had his due process rights there. He waived them, specifically admitted to the conduct by entering the consent agreement, which he signed, according to him, in the document freely and willingly, wherein he admitted that conduct. That conduct is no longer in dispute. It is what it is. The allegations that are made in this matter is that he has been disciplined by another state. The document itself establishes that on its face. It is conduct that, if it had happened here, would be grounds for this board to take action. Again, he has admitted to that conduct, and he has admitted that he did not comply with the board's subpoena. His own testimony has verified the allegations and the violations. The state would ask that the board make findings that the allegations and violations have been established by a preponderance of the evidence, and based upon the conduct and the violations, the state would ask that the board issue an order revoking his license. Thank you.
Thank you for that, Mr. Hartgraves. Mr. Miller, would you like to make a closing comment?
Yes. I just feel like I've been treated very unfairly for what I've done, because, like I mentioned before, I have not had trouble with essentially put with criminal charges on doing any other type of employment except for this one. So I hope you guys can see through.
Okay, Mr. Miller, thank you. Does that conclude your closing statement?
Yeah.
Does the state wish to make a brief rebuttal?
Yes.
Yes. His allegations that he has been treated unfairly are simply without merit. This board has an obligation to protect the public and to investigate when there's potential conduct violations by its licensees. The fact that the board inquired of Mr. Miller of his conduct in another state is not harassment. It's the board doing its job. Again, the facts are what they are. There are violations of this board statute. The fact that he feels that having to answer to this board is harassment, I think tells the board all it needs to know about whether Mr. Miller can be regulated by this board in the future. Thank you.
Thank you, Mr. Hartgraves.
President Leyba, I would like to have legal advice. Can we go to executive session?
Okay. Would you like to make a motion?
Yeah, that's my motion.
Second.
And I have a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, Mr. Miller, we are going to go into an executive session for legal advice. If you just stay in this room, we will exit this room and go into another meeting, and then we will return. So you don't need to do anything. Just stay right there, okay?
Okay.
Okay, thank you. Welcome back from executive session. I'll just look for the thumbs up for Mr. Hartgraves to join and be settled in, and from the deputy director that we're okay to proceed.
It looks like we have Seth back in, so I think we're ready to go.
Okay, thank you. Okay, welcome back, board members from executive session. Mr. Miller, we are back, and this is where the board will now have a general discussion and entertain any motions or making of findings of facts and conclusions. And I will hand it over to board members. Ms. Nair.
I'll make a motion to accept the findings of facts and conclusions of law.
I have a motion, and do I have a second?
Second.
Second by Mr. Dang. All those in favor?
Aye.
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 Any opposed? Thank you, Ms. Nair. Board members, are there any other questions? This would now be the point where we address the disciplinary, accept the state's recommendation of revocation.
I'll make a motion to accept the state's recommendation for revocation.
Thank you, Ms. Nair. I have a motion.
Second.
I have a second by Mr. Dang. Any other discussion before roll call? Mr. Harris, anything I'm leaving out that you'd like me to go back to? Thank you. Dr. Gandhi?
Ruth, line 1.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Sorry, was that aye, Mr. Minkus?
Yes, aye.
Yes. Mr. Leyba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Yes.
Ms. Nair?
Aye.
Thank you. Mr. Hargraves, thank you for your time today. Board members, thank you for your time. Mr. Milner, thank you for your time as well with written documentation. This concludes the case before us today. Thank you. With that, board members, I'm going to call a 10-minute break and we will reconvene with case number 27C 20-0322. Okay, thank you and welcome back from the break. Before we get started with agenda item 2727C, I would like Dr. Gandhi to do a roll call.
Okay, Mr. Solari,
Ready, sir.
Mr. Dang,
Here.
Mr. Minkus,
Here.
Mr. Leyba,
Here.
Ms. Lehan,
Present.
Ms. Wamsley,
Present.
Mr. Todd,
Here.
Mr. Goodman, Mr. Goodman,
Am I done?
Mr. Goodman. Okay, we'll come back. Ms. Nair.
Here.
All right, let's look for Mr. Goodman here.
Mr. President, before you call this case, I am recused, so I'll jump back off.
Thank you.
Mr. President, we have everybody but Mr. Goodman. I don't see him logged on. I will reach out to him here.
While we're waiting, I believe Mr. Miller was asking if he was done, and yes, you are, and we do thank you for your time today. Let's move forward without Mr. Goodman. This is 27C, Alona Yasmin Sanchez, board case number 20-0322.
Mr. Leyba,
Yes.
am I done?
Yes, you are. And we thank you for your time today.
Thank you.
Thank you. This is the date, the time, and the place where the matter dealing with Alona Yasmin Sanchez, board case number 20-0322, is scheduled to be heard by the Arizona State Board of Pharmacy. This is the formal administrative hearing to determine if there has been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include myself, Joe Leyba, Lori Wamsley, Kristen Snare, Kevin Dang, Ruben Minkus, Mohammed Solari, Theodore Tong, Cedar Lehan, and Nick Goodman. I believe Mr. Goodman is absent for this case. Let the record reflect that the board members have been furnished copies of the complaint, notice of the hearing, and all the pleadings of record. Will the parties please introduce yourselves?
Mr. Leyba, this is Lori Wamsley. I am recused from this case, so the record could reflect that as well, please.
Accepted, and thank you, Ms. Wamsley.
This is Seth Hargraves.
Thank you, and Ms. Sanchez. Okay, making note that Ms. Sanchez is not person. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witness, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof that shall present its case first. Would the state like to make an opening statement?
We can't hear Mr. Hargraves, Mr. President.
How about now?
Yes.
Okay. The complaint notice of hearing in this matter was sent out on November 4th, 2020. The complaint notified Ms. Sanchez that pursuant to ARS 1927-01N, she was required to prepare and file an answer with the board regarding the allegations in the complaint within 30 days after service. It further notified her that her failure to respond would be deemed an admission by default to the acts charged in the complaint. Arizona Revised Statute 41-1092.04 requires that the complaint shall be served by personal delivery or certified mail return receipt requested or by any other method reasonably calculated to effect actual notice. Pursuant to Arizona Administrative Code R4-23-115F, service is considered to be made 5 days after mailing by first-class mail or on the date return receipt if mail is sent by certified mail. As I stated, the complaint in this matter was sent out on November 4th to respondent's address of record, as well as to other known addresses associated with her, and it was also sent to her email address. The answer was due by the close of business yesterday. She has failed to answer. As such, pursuant to ARS 32-1927.01N, the state requests that the hearing in this matter be vacated and that the board deem the allegations admitted and adopt the factual allegations and alleged violations of law set forth in the complaint notice of hearing as findings of fact and conclusions of law, and further request that the hearing be vacated, the board impose the discipline of revocation of respondent's license. In this matter, all the certified mailings and one of the regular mailings was returned to the board. However, one of the mailings did not come back, and there was no kickback of the email notice sent to Ms. Sanchez. Therefore, we believe that she has been given proper notice. She didn't respond as requested, so we again ask that the allegations be deemed admitted and this hearing vacated. Thank you.
Thank you. We will now move on to the testimony portion of the case. Would the state like to please call a witness if they have one?
Mr. President?
Yes.
Members of the
We're unable to hear Mr. Harris.
Mr. Harris.
Okay.
Are you muted, sir? Yes, I am.
Mr. President, members of the board, I believe the state is moving to deem the allegations set forth in the complaint notice of hearing as your findings of fact and the allegations of unprofessional conduct as your conclusions of law. So you may want to just consider a motion whether or not to grant the state's motion to deem at this point. And there would, if you do that, there would not be a necessity for the state to present its case.
If I may,
Mr. President.
Yes.
Normally, the state would provide a written motion. However, because they still had until yesterday to answer, a written filing was premature until today. That's why I presented it verbally.
Okay.
Mr. President, I'm willing to make that motion if it's necessary. I will make a motion to vacate this hearing and to grant the state's motion and deem the allegations in the complaint and notice of hearing as admitted.
Second.
Okay, I have a motion and I have a second. And Mr. Solari, I had a little technical difficulty. Could you rephrase your, just so I hear it and understand it, your motion?
I wanted to make a motion to vacate this hearing and then grant the state's motion and deem the allegations in the complaint and notice of hearing as admitted.
Second.
Thank you, Mr. Solari. I had a motion and I had a second. Dr. Gandhi?
Not necessarily.
Okay. Well, we will just do a vote. All those in favor?
Aye.
Aye. Any opposed? Okay, thank you.
May I also make a motion to adopt the factual allegations and the allegations of unprofessional conduct from the complaint and notice of hearing as finding the fact and conclusion of the law.
Second.
Second. Oh,
Goodman, I was muted. I was trying to abstain from the last vote because I missed the discussion. My apologies.
Okay, thank you. And we did note that in the beginning as well. Okay, so I have a motion and a second. There was a pause and I think again, another technical glitch. I'm not sure everybody heard it. I would ask you to repeat it once again, please.
Yes, sir. Make a motion to grant the state's motion and deem the allegations in the complaint and notice of hearing as admitted. Or did I? Oh, I'm sorry, that was the wrong motion. The motion is to adopt the factual allegations and the allegations of unprofessional conduct from the complaint and notice of hearing as finding of the fact and conclusion of the law.
second.
Thank you. I have a motion, a second by Mr. Minkus. All those in favor?
Aye.
Aye.
Any opposed?
And abstain, Goodman.
Thank you.
Finally, I make a motion to grant the state's request to revoke this license.
Second.
Have a motion and a second. Any discussion before a roll call? Dr. Donahue.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba?
Aye.
Ms. Lehan?
Aye.
Walmsley is recused. Mr. Tong?
Aye.
Ms. Nair?
Aye.
And Mr. Goodman abstain.
Abstain.
Okay, thank you. This concludes the proceeding. The board's decision will be reduced to a written order. Thank you for attending today. Agenda item 27D, Christopher Isaac Zion, board case number 20-0316. This is the date, the time, and the place for the matter dealing with Christopher Isaac Zion. Board case number 20-0316-PHR is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there has been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Joe Leyba, Lori Walmsley, Kristen Snare, Kevin Dang, Ruben Minkus, Mohammed Salari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect the board members have been furnished copies of the complaint, notice of hearing, and all pleadings of record.
Excuse me, Mr. President? I'm sorry, this is Cedar Lehan. I need to recuse myself from this one, please.
Okay.
It's already on
noted.
document.
Yes, noted, and thank you. Will the parties please introduce themselves?
Yes, Seth Hargraves, Assistant Attorney General on behalf of the state.
Okay, thank you. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witness, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Would the state like to make a statement?
Yes.
Yes, thank you. This case came out of a summary suspension on the special meeting held on November 4th. The complaint notice of hearing was sent out that same day. That complaint notice of hearing notified Mr. Zion that pursuant to ARS 32-1927.01N, he was required to prepare and file an answer with the board to those allegations within 30 days. It further notified him that if he failed to respond, the allegations would be deemed admission by default of the acts. Again, Arizona revised statute requires a complaint be served by personal delivery or certified mail or by any other method reasonably calculated to effectuate actual service. In this case, the complaint notice of hearing was sent by regular and certified mail to Mr. Zion's address of record and his last other known addresses, as well as to his email address. He had until yesterday afternoon to respond, and he failed to do so. The state would normally have filed a written motion to deem. However, due to the late notice, I am presenting that verbal motion today the state would request that the board vacate the hearing and consider deeming the allegations admitted. The complaint notice of hearing, again, was sent to the address of record and other known addresses. Both the certified and regular mails were returned. However, there was no kickback on the email service. So therefore, the state would request that the board vacate the hearing, deem the allegations admitted, adopt the factual allegations and alleged violations of law, including the previous finding of emergency from the summary suspension set forth in the complaint notice of hearing as findings of fact and conclusions of law. And further, based upon the allegations, the state would ask for an order of revocation. Thank you.
Thank you for that statement, Mr. Hargraves. Board members, the board will now discuss whether the state has proven these allegations. If there are no questions, I will take motions to accept the state's recommendations.
I'm willing to make a motion, sir. I'll make a motion to vacate this hearing and grant the state's motion and deemed allegations in the complaint and notice of hearing as admitted.
Thank you, Mr. Solari.
Second.
I have a second by Ms. Walmsley. All those in favor?
Aye.
Any opposed? Thank you.
The next motion is to adopt the factual allegations and the allegations of unprofessional conduct from the complaint and notice of hearing as finding of the fact and conclusion of the law.
Thank you. I have a motion by Mr. Solari and a second by Ms. Walmsley. All those in favor?
Aye.
Aye.
Any opposed? Thank you.
And finally, I'll make a motion to grant the state's request to revoke this license.
Second.
Thank you. I have a motion by Mr. Solari, a second by Ms. Snare. Any discussion before Dr. Gandhi does a roll call? Thank you.
Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leyba,
Aye.
Lehan's recused, Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Thank you. This concludes the proceeding. The board decision will be reduced to a written order, and thank you for attending today. Okay, moving on to tab 28, motion of from December 10th, 2020. Let's see. This is the date, the time, the place where Rachel Renee Day's motion for rehearing is scheduled to be heard by the Arizona State Board of Pharmacy in case number 20-0263. Is Miss Rachel Renee Day present?
I am.
Okay, thank you and welcome to the meeting. Miss Day, will you please state your name for the record?
Rachel Renee Day.
And would the state please state their name for the record?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Thank you. Pursuant to AAC R423-128D, the board may grant a rehearing of the case if Ms. Days establishes that one or more of the 8 grounds listed in the rule materially affect her rights during this administrative proceeding. The board has reviewed Ms. Day's motion for rehearing and the response to the motion filed by the state. Each party will now have time to address the board on this matter. This is the time for legal argument related to the grounds of rehearing, and the party should not use this time they should use this time to present new evidence or testimony to the board regarding the merits of the case. Ms. Day, in your arguments to the board, please clearly identify and explain the grounds that support your motion for a rehearing. Mr. Hargraves, in your arguments to the board, please clearly identify and explain why the state does not believe Ms. Day is entitled to a rehearing. We will now proceed to the oral arguments. Ms. Day, we will ask you to present first, followed by Mr. Hartgraves on behalf of the state.
Can I proceed?
Yes.
I ask that to be honest, I have no new evidence except that I had completed a 60-day rehabilitation program. I am now in sober living. I am working on my addiction to alcoholism, which is a disease. I take full responsibility for everything that was accused, but I just ask that being a pharmacy tech for 16 years and this being my first violation, I ask that something be put in place as to whether I need to be drug tested randomly for a period of time, or if there is some other alternative rehabilitation that can be given to me to prove my my sobriety, and that I am determined to abstain from all chemical use. I have not put in harm's way of any patient. I was not in the public. I was not with in the public when this happened. I was behind the scenes of the pharmacy. No one was hurt from my discretion, and I just ask that they look at my previous record of being a pharmacy tech, that this is again the first time that anything has come across as a violation, and please reconsider not revoking my license, because I have been a dedicated, loyal, hardworking pharmacy technician for 16 years and have had no discrepancies up until now. And again, I'm working on my recovery, and I just ask that you take that in consideration, all the hard work that I have done. With that, I pass. Thank you.
Ms. Day, thank you for your testimony today. Comment?
Yes, thank you. What Ms. Day presented would have been beneficial to have been presented at the time of the hearing in this matter. Just a little background. On June 15th of this year, the board was notified from Ms. Day's employer that on June 14th, she appeared to be under the influence of drugs or alcohol while at work. When asked to submit to a urine drug screen, she initially denied impairment, but subsequently admitted to being under the influence of marijuana. She was in possession of 2 water bottles that she had been drinking from, one of which contained vodka. July 15th, this board issued an interim order for drug screening, to have her submit to drug screening, including hair sample, no later than the end of the day on July 17th. She failed to comply with that board order. She was sent a notice of hearing. It was an expedited hearing. She was given notice of that. She didn't respond to it. She didn't appear at the hearing. The hearing occurred in her absence. The board heard the evidence and testimony and issued an order of revocation. The first time that there was any communication or response from Ms. Day was after the board had already revoked her license. Under the board's regulations, there are 8 enumerated grounds for which the board can grant rehearing or review, none of which have been argued by Ms. Day. Essentially, what she's arguing is that she has had no complaints in the past and kind of wants a do-over. However, she had plenty of opportunity to cooperate with this board prior to getting to where it is today, and she basically ignored it at every step. Since she has failed to establish any of the grounds to support a rehearing or review, the state would ask that her request be denied. Thank you.
Thank you, Mr. Hartgraves. Board members, do you have any questions for the parties?
Mr. President, may I?
Yes.
Ms. Day, since this matter came to the attention of the board, 180 days have passed and you did not take the opportunity to comply with any of the requests or submit any documentation. Can you explain why? I can understand why for 60 days you were in rehabilitation, but you've had 180 days to do something. Why haven't you?
my mother, who is also a pharmacy technician, actually advised me to not attend the hearing, saying that it would be too hard for me to hear, and she was scared that it would put me into a relapse. So it was not good advice, but I did take the advice from my mother, basically thinking that it was going to not do me any good to go in front of the board. And like she said, it would be too hard for me to hear. And also, I did not submit to the hair sample. I went to the drug place to get a hair sample, and they informed me it would be $238, which at the time I was not employed. I did not have any means of paying for that because I didn't have any savings. So I would have submitted that, but it was too much money for me to acquire, since I would have to be paying out of pocket. So I know that it was me to take bad advice from my mother to not submit to go to the first hearing. But I have since then, like I said, gone into recovery. I am working on my steps. I have a sponsor. I am in sober living. I am doing everything that I can do now to prove that I am sober, and have every determination to stay so. So I really can't I'm not going to give you excuses. I'm just going to be honest with you. And that is why I did not attend the hearing at first. But I am coming in from the board, and I am just really begging you guys and to please look at my history, that I have never had any discrepancy beforehand. And you know, I'm a human being, and I do have the disease of alcoholism, but I am doing everything that I can to stay in recovery and to assure my sobriety this time. Thank you.
Thank you.
Thank you, Ms. Day, for your comment.
I have a question, Mr. Leyba.
Yes.
Can you explain to me what sober living is? It's just an outpatient treatment facility? Is that correct?
No, well, no, it is a house where I have accountability. I get drug tested randomly. I get breathalyzed every single night when I come home. I am mandatory of 5 AA meetings a week, or NA meetings, or any meetings. I also forgot to mention I am in intensive outpatient through the Rehabilitation Center of Unhooked, which is where I was inpatient for 60 days. I am now continuing treatment outside of that, where I go for 3 days a week for 3 hours. I go from 5 to 8 at night, Monday, Tuesday, and Thursday. So I get extra counseling through them. But yes, sober living is just where I live. You have to be sober. They can submit any random drug test at any time, and I am breathalyzed every night. And I have a chore that I have to do. I have to maintain employment to stay there. It's kind of like a step lower of being inpatient.
Okay. And you're free to leave anytime. It's just a voluntary thing that you've chosen to do. Yeah.
Yes.
I'd like to make a motion for executive session for the purpose of legal advice.
Second.
Okay, I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Okay, Ms. Day, we are going to go into a private room, and you can just stay right here, and when we are done, we will return and pick up where we left off.
Thank you.
Thank you. Okay, welcome back, board members from executive session, and Ms. Day, thank you for your patience. Board members, I'll open it up for discussion.
Mr. President, may I?
Yes.
Ms. Day, who is the provider that is doing your rehabilitation services?
It's called Unhooked Recovery. It's in Mesa.
How much longer will you be with them?
Well, I just started the outpatient services, and it goes for 3 months, and I've only been in it 2 weeks. So I still have a great deal of time left.
Thank you.
Mr. President, can I ask a question?
Yes.
Are you living there at that house over the next couple of months?
I am living in sober living, yes, and I plan to stay there as long as I possibly can. Yes.
And then where do you plan to go after that? Do you have a place to go afterwards?
Just until I can get on my own feet. But I mean, people stay in sober living for, years. The longest I've heard is someone staying in sober living for 3 years. So I will only leave when I feel that I'm ready to leave.
So you leave on your own. They don't say, hey, you're ready to go, get out.
Correct, yes.
I'm kind of conflicted on this whole thing. I think she's making the correct steps going forward, but I don't think enough time has passed to let her get her license back and go. So I think my suggestion would be to keep going on the approach that you're going, knowing that you can reapply in 2 years, get on the right track, and then come back to us and let us see where you're at then. And over the next 1.5 years or 2 years, you've got to prove to us that you've learned your lesson and that you've gotten on the right track. And then I think the door probably will slightly open for you to give you another chance. And hopefully this is a valuable lesson that you learned.
That is all that I ask, sir, is to just be given another chance. I completely appreciate the opportunity to be given a second chance, even if it means in a year. I completely understand how I need to prove myself and I need to show accountability. So that's actually more that I could ask for today, is just be given the chance in the future.
So then I think my motion would be to deny the request for another hearing or revisiting this. And then when the time frame fits in 2 years, to come back to us and let us look at it again. And please do well. We want you to succeed. We really do. That's my motion.
Second.
Okay, I had some computer difficulty here. I just want to make sure I got that right. Mr. Minkus said that he would deny the motion, and there was a second, deny the motion for hearing, and there was a second by Ms. Snare.
Yes.
Okay, any other discussion before a roll call?
Just one clarification, Mr. President. The first opportunity for Ms. Day to reapply would be September 2022. That would be the 2-year mark.
Yes.
That's fine.
Okay, having said that, Dr. Gandhi, we'll do a roll call.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Aye.
And Ms. Nair?
Aye.
Okay, ayes have it, Mr. President.
Okay, Ms. Day, your request for rehearing has been denied. I want to thank you for your time today and congratulate you on your journey and encourage you to keep going. You can do this, and you are welcome to reapply in 2 years.
Okay, thank you very much for all your time. I appreciate it.
Thank you. Okay, it is 10:39. I'd like to take a 10-minute break. I'm having some pretty significant lag on my audio and it's a little bit choppy, so let's see what we can do on that on the break. But we'll come back after a 10-minute break and we will pick up on either the conferences, depending on what Jennifer directs, or on 29 special requests. Thank you. All right, welcome back, everybody. Before we kick off, I'll ask Dr. Gandhi to do a roll call.
Mr. Solari?
Yes, sir, here.
Mr. Dang?
At your service.
Mr. Minkus?
Here.
Mr. Leyba?
Here.
Ms. Lehan?
Here.
Ms. Walmsley?
Here.
Mr. Tong?
Here.
Mr. Goodman?
Here.
Ms. Nair?
Here.
Okay, thank you. At request, we will move to 15A. This is Women's Choice Pharmaceuticals, Inc. under non-resident wholesale permit applications requiring board the representative in the meeting for Women's Choice Pharmaceuticals.
Mr. President, after we announced this agenda item yesterday, we did reach out to them, and I don't believe they heard back. And we did delay representing it until today.
Okay, board members, I feel we do need to hear from them to see what is going on. There sometimes are explanations. Otherwise, we can't make that leap decision without talking to them and understanding what's going on. My request at minimum would be to table until the next meeting.
Mr. President, would you also like us to issue a cease and desist from shipping from an unpermitted facility?
I think because they don't have the ability to tell us that they're not doing it, we have to your point. So board members, if there are no other questions, I would make a motion to table and to issue a cease and desist to the permit holder.
Second.
I have a second by Ms. Snare. Any discussion before a vote? Mr. Gandhi?
Roll call, sir. Yeah, given the cease and desist problem.
Okay, Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Aye.
Ms. Nair?
Aye.
You can pull up 17D next, Mr. President.
Okay, thank you. 17D. UI Pharma USA Ltd.
And Mr. President, after we called this agenda item yesterday, we did reach out to them via email yesterday, and I don't believe we've heard back.
Okay, board members, I would recommend and make a motion to table until the next meeting.
Second.
Have a motion and a second. All those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, thank you. Moving to
20E, Mr. President. I believe 20E was addressed with the hearing earlier, so
E was, okay.
yes. And then 20F, Mr. President.
So we need to move to 20F, okay. 20F, Mr. Don Brewer. Is there a Mr. Brewer present?
Yes, sir.
Welcome, and if you would state your name for the record, please.
It's Marley Don Brewer.
Okay, thank you. Mr. Brewer, can you tell us a little bit about what your request before the board is today?
It's just pertaining to my consent agreement that I signed with the board. It's been 6 months and 20 days, I believe, since I signed the consent agreement. So I am just looking to petition the board for my license being moved from suspension to probation.
Okay, thank you.
And for the record, Mr. President, this is item 20F, but it's also his special request to remove his suspension.
Okay, thank you. Board members, there is a letter of support for Mr. Brewer's request to terminate suspension from the director of the PAPA program. And I'll open it up for any discussion you may have or questions for Mr. Brewer.
May I, Mr. President?
Yes.
Congratulations, Mr. Brewer. Do you intend to continue with the next 4.5 years as outlined in your contract?
Absolutely, and not just continue for that length of time. This is something that I realize I'm going to have to do the rest of my life.
Very good. Thank you, sir. If there's no more questions, I'm willing to make a motion, Mr. President.
Thank you.
I'll make a motion to grant Mr. Brewer's request to lift the suspension of his license and allow him to continue in the probationary status for the next 4.5 years. If he successfully completes, he'll come back and request for the probation to be lifted.
Okay. Let's have discussion here right before. Let me make sure. Board staff, are we all in line with the documentation that we need for Mr. Brewer? I thought I remember seeing something that we may need some additional consent on this one.
Mr. President, this is an interim consent agreement. We would need to move to a consent agreement for the remainder of 4.5 years for monitoring.
Mm-hmm.
And that's all that would be needed at this time.
Okay, Mr. Solari, I'll hand it back to you.
Mr. Brewer, will you be willing to sign the consent agreement that the board offers you?
Yes, I would.
May I withdraw my previous motion? I'll make a new motion. I'll move to allow to grant Mr. Brewer's request to have the suspension of his license lifted pending signing of the new consent agreement, and allow him to serve the remaining 4.5 years of his probation based on the terms of the new consent agreement.
And would his renewal be conditioned with that?
Yes, ma'am. Thank you.
Thank you, Mr. Solari. I have a second. I have a motion. Do I have a second?
Second.
Second by Mr. Minkus. We'll do a roll call.
Okay, Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong? Mr. Tong?
Aye.
Mr. Goodman?
Aye.
Ms. Nair?
Aye.
Okay, thank you, Mr. Brewer.
Thank you.
You have a good day. Moving on to 25D, 20-0042. Conferences. This is for Charles Michael Tidwell. Mr. Tidwell, are you present?
Yes, I am.
Mike Tidwell on here.
Okay. Mr. Tidwell, if you would state your name for the record and welcome to the meeting. You're on mute, Mr. Tidwell. Let's do this. I think Mr. Tidwell may be having some complications. Let's move on to 25E, and then we'll come right back to that. And by then, maybe he'll have his mute, or his technology will be cooperating with him. 25E, 2020-21. This is subject of Omega Medical Supply. Do I have a representative for Omega Medical Supply?
Mr. President, we were informed that Omega Medical Supply was not going to attend this meeting. I have been in contact with a conflict management resource company. We requested a power of attorney for that person to speak on behalf of Omega. I have not yet received it. I did just shoot her some communication to see where she's at, where the person's at, getting me that information. I have not heard back. You're muted, Mr. President.
We've tried 2 times now, board members, to be in contact. It does appear that we have somebody who is shipping without a permit or permit. If you look at page 3250 of your reading under possible violations, that is what is on the table at this point. Knowing that they have tried to reach out through the conflict resolution, it's been slower. And they've already received a cease and desist. I would refer to legal counsel to see what our options are at this point. I don't believe that we have a signed copy of the cease and desist. Ms. Dodge, you might know that off the top of your head.
We have.
We do have a signed copy.
Yes, and it's been, we've been working on this for quite a while, but yes.
Okay, so they received that. There's a cease and desist. They should have stopped. If not, we find out that during our next communications with them, we can act upon that. So therefore, I would think that tabling this would be a reasonable outcome. And I'll give.
May I get a clarification on that, sir?
Yes.
When you say tabling it, would that mean this issue is going to come up in front of the board again and to determine if they have shipped or not since they've received the cease and desist order?
And determine the final discipline, yes, if they have.
And just to confirm, they're actually located here in Arizona.
So if let's say next meeting they don't reply to us or appear again, do we keep tabling this interminably, or do we at some point say enough is enough? And I like you said, I don't know what our options are, but at some point this has got to come to some conclusion.
The only difference in this right at this point is that they have had contact with Dr. Gandhi, although it's been unsuccessful. There has been contact. I would imagine that if nothing transpires between now and the next meeting, that Mr. Solari, at that point, I would suggest that we act without hearing from them. Legal counsel, if you have any opposing views on that, we can entertain them before the board makes a decision.
Well, under your statute, regarding someone practicing who's required to be permitted without a permit, the board is authorized after formal hearing to issue civil penalties not to exceed $1,000 for each violation. So if at this point we have an idea of how many violations we have, the board could set it for hearing and for that violation and possibly impose a civil penalty.
I'm not aware that we know that, Ms. Dodge.
That's correct. And for the record, the owner, Mr. Stodchill, had been communicating with me and seemed or appeared to want to do the right thing. But it didn't seem like we saw a lot of action. So he would say he's going to stop selling, XYZ, and that never happened from the website. I understood that he was like many of the other companies that we deal with, that they generally or genuinely want to do the right thing, and we're trying to do the right thing. However, at some point he just it stopped, and again it stopped, but we heard back from the conflict resolution.
Okay, Mr. Slyer, are you comfortable with that explanation?
Yes, sir. Maybe instead of we're tabling to the next meeting, but if we don't hear from them by the next meeting or come to some resolution, then we'll go to hearing. Would that be okay?
We could definitely at the next meeting make that a motion.
That's great then.
Okay, let's go back to 25D and let's see if Mr. Michael Tidwell is
He
available.
is, he is back online.
Do we need to vote on the motion to table or?
No, we don't.
Okay.
Okay, Mr. Tidwell, this is case number 20-00400042. Will you please state your name for the record?
Charles Michael Tidwell.
Okay, welcome to the meeting and thank you. Tell us about, we have a complaint in front of us today, and I would like to see if Ms. Dodge, you're listed as the compliance officer, if you could give an overview, and then Mr. Tidwell, after board staff is done with the overview, I'll take your opening statement as well.
Sounds good. This is case 20-0042. In January of 2020, Mr. Tidwell notified the board of a DUI charge. The DUI charge also involved a controlled substance prescription medication. Mr. Tidwell is the owner and PIC of a pharmacy in California. Mr. Tidwell claims he routinely picks up refused meds from the long-term care facility for which his pharmacy services. These medications are refused meds or therapeutic changes. He states that he'll put the meds in a baggie or empty vial. Mr. Tidwell was issued an order for a substance use evaluation. The opinion of the evaluator states that the participant does not meet criteria for diagnosable substance use disorder and does not meet the threshold for mandatory participation in monitoring. However, the evaluator also noted that the description of circumstances around the lorazepam or the prescription medication that was found on Mr. Tidwell with the DUI seemed too coincidental.
Thank you, Ms. Dodge. Mr. Tidwell, would you like to make a statement?
I don't know what I should say. I'm sorry, I've never been through this.
Sure, Mr. Tidwell. You're here for a conference for what took place. This is your chance to explain to the board members that are listening an explanation of what took place.
Okay. As was stated, I was arrested for a DUI, and there was a vial with 2 tablets in my car. What had happened was, like she said, we pick up medications from our long-term care facilities for destruction. And the medication, I had picked up a large box and I had sent pictures to the board of what it was. We bubble pack the medications, and typically if the patient spits out a medication or refuses it, they will put it in a baggie or a vial or something. We recommend that they don't do this, but typically they do. I had picked up a box of medications and did not realize that the vial had fell out. When I unloaded the box at my pharmacy, didn't realize that the vial was in there, found it a couple weeks later when I was cleaning my car, put it in my console, and I forgot about it. I was, and intended to take it back to work to destroy it. And that was in my console, and that is what they found.
Okay, thank you, Mr. Tidwell. Board members, I'll open it up for questions.
Can you remind me, was the bottle labeled?
No, it was not.
Is that the practice? You take the label off? I just think, like, as a pharmacist, transporting something that's not labeled would be a little out of character, I guess.
True. Like I said, all our medications are bubble packed, and they're labeled in the bubble packs. But for whatever reason, if a resident spits out the medication, what we recommend for our long-term care facilities is to put it into a sharps container where it can't be accessed and it can't fall out, anything like that. But typically, they don't follow our instruction. And, in this instance, they had, placed it in a vial and thrown it in this box for destruction.
Do you have a return distributor?
Yes, we use RX distributors that we, they dispose of any, unwanted medications that we have.
But you're the person that takes it from the facility to where?
From the facility to the pharmacy, and then we ship it via the RX distributors for destruction. And just as a side note, we have discontinued this policy just because of the instance that has come up.
What is your position at the company?
Myself, I'm the pharmacist in charge.
Okay. Has this been, has the charge and this case been referred to the California Board of Pharmacy? And if it has, what's taken place there?
Yes, it has. They have reviewed my case, and everything that I have done that the court has stipulated for me to do, and basically reprimanded me and put me on notice that if anything in the future happens, that I will be severely dealt with, as far, I would probably lose my license, they're telling me.
Expand a little bit more on dealt with you and reprimanded you and put you on notice. What does that mean to you?
Well, it would, due to COVID, it was all done over the telephone. It was several calls over, the last year. In that time, I have served a jail sentence. I've done, AA meetings. I've done counseling, and have been sober ever since, and have stopped drinking.
Did you sign a consent agreement with California?
No.
Board staff, do we have proof of that that this was heard and fully closed with the California Board of Pharmacy?
I personally dealt with the California Board of Pharmacy, so I know they're fully aware, and they're fully aware of all of the details of the case, including the prescription drug. I am not aware of the outcome of that, so I wasn't privy to that information.
Mr. President,
Yes.
I have a question from Mr. Tito. So, Mr. Tito, you mentioned that what's baffling me about what you had shared with the board members is that when the patient spit up the medication, you were instructed by the reverse distributor to collect that tablet and bring it to them?
No, the reverse distributors is just a company that we use to dispose of medications, for whatever reason.
Right.
Expired medications, that type of thing.
Right.
Even stuff that we're dispensing that has expired. They process all of our returns.
What about those medications, those tablets that were spit out by the residents?
Medications that are, deemed unusable by the long-term care facilities, they will set them aside, and periodically we will pick them up, bring them back to the pharmacy, and then return them via RX distributors.
Okay, but I heard something you mentioned about when the residents spit up the tablet, you collect them in a bottle and bring it to reverse distributor. Did I hear it correctly?
Yeah, well, then I explained it incorrectly. The medications really that I'm talking about are medications that are refused. Let's say they pop them out of the bubble pack, the patient refuses to take them, and then they have these pills that they need to do something with. So we tell them to put them in a sharps container, but from time to time, they'll just, if they have a prescription bottle, an empty bottle, they will put them in it. We discourage this, but it does happen. And this is what had happened. There were 2 tablets in a vial that was in the box of returns that had fell out in my car.
Okay.
Mr. Danger, you finished? I'm sorry.
One last question, Mr. President, because I used to work as a consultant pharmacist for long-term care, and the policy for handling controlled substances at the long-term care setting is very strict. Anytime when you have any medications that are refused by the physicians, 2 licensed practitioners have to waste it. There's no such thing as you collect them and then bring it back to the reverse distributor. That's the part where I don't think you're giving us the right explanation.
The facilities that we deal with, I say long-term care is a broad spectrum. Our facilities are board and care facilities. They're not skilled nursing. You know, they don't really have protocols in place.
Mr.
Well, then
President,
you as a pharmacist, you should have advised them of the proper policy and procedure. Those are the things that they would rely on you as a consultant pharmacist or as a pharmacist.
True, and you know, like I stated, we recommend that any loose tablets that they need to, you know, process, need to get out of the facility. In the meantime, we tell them to put sharps container. At least that way they're sealed away, so you know nobody can have access to them. You know, and then at that time we pick up the sharps container, bring it back to the pharmacy, and then destroy the medication via RX distributors. We mail it to them.
Okay. Thank you, Mr. President. That's all I have.
Thank you, Mr. Solari.
Yeah, Mr. President, my experience has been similar to Dr. Dang's. If the nursing home is returning something, there needs to be some inventory record of it, so that when Mr. Tidwell goes to pick it up, he knows what he's getting, where the lorazepam is, where the morphine is, where the diltiazem is. And so I would like to see if Mr. Tidwell has an inventory record from the nursing care facility that outlines what meds they're returning, which controlled substances they're returning, how that's done.
Like I stated, these are not nursing homes. They're not skilled nursing facilities. They're board and care facilities, and they do have what we call centrally stored medication records, and they will log on there. You know, medication was returned to pharmacy, that type of thing. But there's not any anything beyond that.
When you pick the medications up, do you inventory them? Do you go through and say, here's a bubble pack that says 2 lorazepam that the guy didn't use. Let me write this down on my return to the reverse distributor list, so that they provide some documentation to you saying they're destroying your controlled substances the same way they do for my workplace.
Right. We have not in the past. Like I said, we have stopped that policy. We're having the facilities deal with medication destruction on site, via the medication take back programs at like your Walgreens and CVS, that type of thing, and the DEA take backs.
Not necessarily related to this incident, but do you have records from your reverse distributor for other controlled substances you've returned to them to destroy?
Sure, yes. You
have those in file if we request them?
Yes.
Thank you. Thank you, Mr. President.
Mr. President, one other question, sir.
Yes.
So, Mr. Tittle, you kept referring to we. Are you referring to the company that the pharmacy that you worked for?
Yeah, I would assume so. What was I saying? We.
Well, you all say we changed the policy.
Oh,
we
yes.
didn't do this.
Yeah, yes, I mean the pharmacy.
Okay, I would feel more comfortable if I like to see their policies, because I highly doubt that the company's policy does not address the requirement of proper narcotic inventory. I highly, highly doubt that.
So Mr. Tidwell is the part owner and the PIC of the company.
And I think,
Yeah, I don't think that this is going to change the fact that he had some in his possession.
yep.
And
Like
then
the reason
maybe
I'm bringing this
change
up
the
is
policy.
because, in my opinion, the reason I'm bringing this up is because I have a feeling that he is not taking the accountability of all the wrongdoings. He kept referring to the policies, and as a company that runs consulting pharmacy for long-term care or any facilities, these facilities should follow the guidelines strictly.
I think we might be getting a little bit away from the
Yeah.
actual issue that's at hand here today. Mr. Tidwell, is the pharmacy that you work at even licensed in Arizona? This is a California licensed pharmacy, correct?
Correct. No, they are not.
So the pharmacy that you were filling prescriptions for is not licensed in Arizona. You hold an Arizona license for what purpose?
I applied for the license like 15 years ago. I have a vacation residence in Arizona, and I plan on retiring there, probably in the next 5 years. And I just wanted to have a license in case I needed to practice, for extra income after I had retired.
But you're not practicing in Arizona today, and this conduct did not occur from an Arizona licensed pharmacy or
Correct.
occur in Arizona.
Correct. I've never practiced in Arizona.
And you self-disclosed this incident where you were charged with the DUI, and that's why you're here today.
Yes.
Okay.
And
So-
it's your first and only DUI.
Yes. I've never had an arrest before.
Miss Walmsley,
Go ahead.
before you move forward, I'd like a chance to ask a few questions if you're getting to that point. I wasn't sure if you were.
I was. Go ahead, Mr. Lewis.
What concerns me, board members, here is we have a situation where the act of what he was pulled over for is one thing, but you look at a cloud of information that's confusing. So for one, he's pulled over in that car. Out of all the medications he takes back and forth, we're to believe that a bottle unlabeled with tolurazepam falls through the cracks, and for a period of time it doesn't make it to his front of his mind to bring it into the pharmacy. That is troubling to me. The other fact that is troubling to me, when he was taken in, the testing was done, and board staff, correct me if I'm wrong, but the concentration of the alcohol prohibited the testing of other substances. So therefore, we don't know if there was anything else in the blood because the alcohol concentration was at a point where it couldn't test for the rest. The last thing that bothers me on this is that when asked the question, what did California board do? It's very generalized and it's very non-specific. And if I went in front of a board, I would be very certain what took place. It sounds almost like a little bit of probation, but I don't know. I would be very cautious as a board on this one, just citing the act of self-disclosure. I am concerned about the spare tablets. The policy and procedure is something that he needs to vet out, and he needs to be acting under California law. But the finding of the 2 tablets, in my opinion, is concerning under the circumstances of how he's pulled over and hearing his explanation. It would be my opinion to see what California actually did. If there was no consent, I want to see what was taking place and how he was supposed to straighten up. And then I think I could move forward after that point. If not, I would be looking at a minimum of probation because of unlabeled medication found in a vehicle.
Mr. President, if I may, Mr. President, Mr. Tidwell, you take that inventory from that facility back to your pharmacy in California to return it to a reverse distributor. Is that what you're doing?
Yes.
So isn't that also considered a unpermitted facility doing business in Arizona per se, Mr. President?
I think Mr. Tidwell said that it fell out of his one of the bags that he was using, which is why it was still in his vehicle when he was visiting his house at Havasu. Is that right, Mr. Tidwell?
Yes. Yeah.
Gotcha. Okay.
I do not practice in Arizona or do any pharmacy related things in Arizona.
Board members, I would make a motion to direct board staff to reach out to the California board, get any documentation that they may have, and then add it to our next meeting for us to make a decision.
I'll second that.
I have a motion and I have a second. Any other discussion before a vote? Oh. Aye.
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 Any opposed? Okay, Mr. Tidwell, we will be in touch with you. Board staff will reach out to the California board. Nothing is being done at this time. We're just doing a little bit more investigative work. Thank you for your time today.
All right, thank you.
Okay, Mr. President, if we can move to 29. And 29A and B has been pulled from the agenda, so we can move to 29C.
Okay, thank you. 29C is a deviation request follow-up from Consensus Pharmacy, long-term care facility, pharmacy services, emergency drugs. Looks like Mr. Gundy, you're involved in this. I'll let you bring it forward to the board, and then we'll take any questions the board members may have.
Certainly. Consensus Pharmacy is wanting to use asking for a deviation for technology. And they want to put in a unit here allowing a non-pharmacy personnel to load the cassettes. We do have Ms. Christine Pack with us here during the meeting. She can probably explain the technology better and see if it fits into our deviation definition. Ms. Pack, are you able to unmute?
Yep. Hello, my name is Christine Pack. I'm the pharmacy director for Consensus Pharmacy. Our permit number is Y008428. Today I'm asking for a deviation, like Dr. Gandhi has stated, to have our nursing staff actually just load our QBs into the QBEX machine, which is going to be the automated emergency dispense machine that we'll have in our skilled nursing facility in Arizona. We are actually a non-resident pharmacy. We're located in Las Vegas, which is one of the reasons we decided to put a tower into that building, just for the patient's safety. I know a lot of people are aware that currently a lot of skilled nursing homes are using emergency tackle boxes. We just wanted to make sure that we had a better stock and more stock of medications that would be readily available for our building in Phoenix. With that being said, I just wanted to talk a little bit about how our QBEX machine works. Karen Nishi, our QBEX representative, is also on the call today, and she could also give you a thorough walkthrough of how the machine works. But the basics of the machine and the deviation request would be to have a QB loaded into the QBEX machine by a nursing staff. Karen, do you want to go over that with them?
Okay, my name is Karen Nishi. I'm Director of Regulatory Affairs for QBEX. We're actually based in Phoenix. But what we have is we have a small automated box similar to a QBEX machine. But instead of having just dividers and like a open type drawer, like a silverware drawer in your kitchen, what we have are separate and distinct cubes with a lid, and each cube on the bottom has an electronic chip similar to what's on your credit card, a chip, and then the label has a corresponding barcode. These, we call them QBs, are filled in the pharmacy. They're checked, labeled, sealed, and they're shipped out, they're sent with the complete order to the long-term care facility. In other states, the facility signs the manifest, takes the bingo cards, the drugs, the orders, and everything, including the QBs, and puts them away. Arizona has a regulation that requires the pharmacy specifically to fill an automated unit. So in the case of Consonas, they want to use a Cubex mini unit to replace an automated manual tackle box. So to sign on to our machine, the nurse, we're requesting a nurse to do this, logs onto the machine with their fingerprint and a secret password, their own personal password, and then a list of the patient's names come up. They'll select that patient's name and then the medication ordered for that patient. Once that's done, the drawer will open and then the specific QB with that drug, the lid will pop open. So then they can remove the drug and administer to the patient. When the box needs to be refilled or that drug, an electronic message is sent to the pharmacy and it says, this machine at this facility, this drawer, this QB needs 2 amoxicillin capsules. That is an electronic message. It's filled and checked in the pharmacy, shipped out to the facility, and then the nurse would sign for it, log on to the machine, and then place that QB into the pocket, into the machine. So the backup, what it has is it has fingerprint identification, it has patient ID, it has drug ordered or the drugs that are ordered, and it has chip technology. So we're asking that a nurse be allowed to place it into the box because with COVID, the pharmacy has to go to the facility, call ahead of time, get into the PPE, get admitted to the facility, and then walk in to swap the QBs. So that the system is much safer than a manual tackle box, but because it's automated, the regulations currently state that they want the pharmacy to fill. But at the time, I believe the regulations were written, there was no chip technology, there was no interface saying what's low, what needs to be filled, or the reporting capabilities. So because of the advances, because of COVID, we are working with the pharmacy and hopefully we can have the nurse place those filled, checked, barcode, and chipped QBs into the machine.
Okay, thank you, Ms. Nishi. 2 things before I turn it over for board questioning. One, I'd like to see if I could get a legal stance on this from board staff or council. And then 2, I would like to hear from Mr. Solari and Mr. Dang on what they think of this loading of the machine with their experience in the settings that they're at. So first, before we go, I'd like to have a legal perspective on what the request is here today. Dr. Gandhi.
Trying to figure out how to unmute, Mr. President. So the deviation is experimental and technological based definition today. This machine, according to Consonas, does meet the definition of technology. I'm not sure if it's experimental. You've already tried this in other states, am I correct?
Yes, that's correct. Currently what we're doing in our facility here in Nevada, we actually have a building that has tackle boxes and we have a building that also has the Cubex. I believe you said that you guys had people who have were pharmacists that have been in long-term care facilities and have assisted in this, but the tackle box, the reason we actually went to the Cubex model was in our other states, they have actually experienced a lot of controlled substance diversion because the tackle boxes are so easy to get into. And the QBEX just made it a lot more safe to prevent this from happening. So yes, it is being utilized in one of our homes right now. And a nurse is currently loading it. We do have a policy and procedure around that. And also, I believe I forwarded the Nevada regulations to you and also Dr. Dodge as well, just to show that it does not specify that a nursing personnel has to load the QBs in.
And Dr. Gandhi, this is Dave Keller with QBEX. I would also like to point out that we are currently approved in 40 other states for this process. There's currently just 10 states that do not allow the nurse to fill, and we're working with several of those states, including today with Board of Arizona.
This is Goodman. Did I hear that correctly, that it's being filled in your home?
Home state.
Home state, sorry, okay. Thank you.
Fully integrated with the pharmacy system, and the pharmacy is filling the QB in the pharmacy, and that QB is then being delivered. It's secured, as Karen Nishi talked about. It has a microchip. It's got a label with a barcode scan, and then is sent to the facility, where the facility then can scan and place into the unit.
The challenge
To the skilled nursing facility.
Challenge, Mr. President, is we're overlapping disciplines, and we don't have authority. If a nurse makes a mistake or something, we don't have authority to deal with that situation. The other thing is we do have technology similar to what they presented by other companies, and we have not offered that deviation to other companies in this state as well. And this company is not located in this state, obviously.
If we had them contract out with a local pharmacy to go in and maintain the machine.
That we have allowed.
I believe the other machine you're talking about does not have the chip technology. So on the bottom of our QBs, that QB can only be set in that machine at that facility in that specific drawer. So our competitors do not have the chip technology. They have barcode.
Mr. President, may I speak?
Yes, thank you.
So a couple of things. I have experience with, we have Pyxis in our facility, and Pyxis does have something similar to what Ms. Nishi is explaining, where that QB only fits in that specific design space. So there is she is correct that the opportunity to make an error by the nurse is not present. The question is, should it be a pharmacy personnel that goes and does this, or should it be a nurse that does this? In the setting of COVID, I kind of see their point that we don't want a lot of unauthorized people or a lot of unnecessary people going into these facilities, and they may transmit COVID to these vulnerable residents. If we didn't have COVID, I would stay with our existing policy and say, don't let, have only pharmacy personnel do this. Don't let non-pharmacy personnel do this. But because of COVID, the fewer people that go into these buildings, the better. So if somebody's delivering this QB to the site, nobody could make a mistake here. It only fits into that particular space. It is safe. We have this in our facility with their competitor Pyxis. You can't screw it up. The problem I have is the definition of emergency. At least in my facility, emergency refers to a cold arrest or that kind of thing. These guys are talking about amoxicillin and drugs that essentially an emergency dose or a first dose, not necessarily an emergency. And so I am having a little bit more difficulty with the concept of them calling a first dose an emergency drug. So that's my input.
Mr. Solari, there are regulations that skilled nursing homes have to abide by, that a first dose is given within so many hours, whether it's a emergency or not. That's kind of another topic, but that is what causes many of the nursing staff to get into a emergency type fill.
Right, I agree. Yeah. But she is describing the technology she's describing. I've worked with their competitor, and I do agree with what she's saying. You can't screw this up. So,
and Mr. Solari, this is Dave Keller talking again. We are actually owned by BD. Pyxis Care Fusion. So they are our parent company.
Very well.
Our software is just designed specifically for long-term care.
Okay.
Mr. President.
Yes.
So from my background, I have been working with a lot of these units, Omnicell, AccuDose, MedSelect, and Pyxis. And Mr. Solari is right. They all, although the names may be different, but they all have the same function. The main question I have for Ms. Nishi and Mr. Keller is, this box that you're referring to, do they have individual lid on every single pocket?
Yeah. So I think, Mr. Dang, that the difference with Omnicell, MedSelects, Capsas, and some of the others, they do not have a QB exchange. So they are actually filling that unit by taking medications in a bag, potentially with a label that the nurse is scanning, where ours are actually in sealed, lidded, individual QBs. Don't have one here next to me, but I have a PowerPoint that I could show you a picture. I don't think I have access to share, but these QBs are labeled, checked by the pharmacy and a pharmacist in the pharmacy, and are sealed, tamper evident, microchipped, as Karen talked about, and then delivered and then exchanged with the nurse being able to scan the barcode and put it in. So the nurse never has access to those medications and opening those medications. The Omnicells, the MedSelects, the MedDispense, the Capsas, they have access to those medications because they're being delivered in a baggie or a bag type delivery process where they're emptying them into a fixed pocket that's in the unit.
I just wanted to add, Dr. Dang, I just wanted to give you an example of what our QBs look like. This is basically our QB. So what happens is we actually have a machine called the CR machine in our pharmacy. So these QBs are loaded into our CR machine at the pharmacy. And what a technician does is they'll go in, they'll fill this QB. And once they're ready, they will flag the pharmacist and be like, hey, I just filled this QB, let's say, for example, with the amoxicillin, and I need a pharmacist to come verify this. So then our pharmacist will go, same idea, fingerprint, password, access, and they'll go in and they'll verify this QB, which would have a label in here that labels like the medication, how many is on there. And if you see this empty space here, that's where our pharmacist would actually initial off on. Just stating like I'm the pharmacist that verified this QB and the contents in here are correct. At that point, after all of these QBs are verified by the pharmacist, the lid is closed, and at this point, this QB is locked. And we can't open it until it goes into a CR machine again, or some kind of QBEX machine. So at that point, this QB is assigned to the QBEX machine at the building that we're trying to send this QB to. And a manifest is also printed with these QBs, and the manifest will basically list for the nursing staff, you know, what medications we're sending, how many we're sending. And once this is popped out, we send it to the facility. And what the nurse basically does is they will basically just scan this code, which is a smart QBs. If you could see, they have like these little chips at the end. And basically all the nurse does is she'll just pop these into the machine. So she never opens this. She doesn't do anything. It's already been verified by a pharmacist. So all she has to do is just put this into the machine to be utilized when needed.
Can it be opened by the nurse if the nurse chooses to open it?
It's locked. The only way they can open it technically is if like they are trying to give it to a patient, I guess. So if they need to give it to a patient at some point, the drawer open, kind of like the Pyxis. If you select a patient and they need to dispense a dose to a patient, that's the time when the QB door would open and give them access to pull that medication, and then they would close it again.
That is the part where board members, that's the part where I'm a little bit concerned with. If somehow if the QB, when you deliver the QBs to the site and the nurse cannot open that QB whatsoever. All he or she can do is just insert that little box into the unit. I'm fine with that.
Mhm.
The issue that I have run into at my workplace over the years is that that's why I have my technicians take care of it. Otherwise, I can't sleep I would not have a good night of sleep.
Mhm.
When we deliver the medication to the freestanding ERs, if they're not tightly regulated, nurses can access any medications at any given point in time before these medications are loaded into Omnicell.
So
that is a part where we have to have a tighter control of the prescription meds. Nurses cannot take any of those unless they follow the proper procedure by logging into the unit and remove each individual dose of medication and administer it to the patient.
And that would be the process, Mr. Dang, with they cannot access that QB. They would take that QB, which is sealed and locked, as Christine has mentioned. They would place it into the QB, into the spot. They would close the unit. When they're ready to administer or grab a medication, again, that's when the drawer would open, but they would have to, again, identify themselves, choose the patient, choose the medication, then only that QB, similar to an Omnicell or other units, and then have access. They do not have access in the delivery or loading process of that medication.
I understand that process, Mr. Keller, but Ms. Pak just shared with me that when I asked her, if the nurse wants to remove the medication, can the nurse open that little box? And she said, yes, if the nurse wants to, the nurse can still open that box.
Only for administration to a patient.
Oh,
Is what I meant. Sorry, I must have been confusing.
This is actually safer than the tackle box thing, because it's the same in the tackle box. Once the tackle box is open, anybody can get in there and take whatever they want. So this is actually a little bit safer. So they're actually doing a good thing here. The question here really to me is, who should be doing this? Is it the pharmacy personnel or the nursing personnel? To me, I would you all know I don't like deviations, and I take them very seriously. But in the setting of COVID, the fewer people go into these resident homes, because these populations are very vulnerable, the better. So I think during the period where COVID is a surge or the COVID is with us, I think this is a good idea. Once COVID is gone, or vaccination or whatever happens down the road, we can come back and visit this. But I think I would recommend we grant this deviation for the period of COVID.
Mr. President, I would like to make a motion for executive session for the purpose of legal advice.
I would agree with that, Ms. Walmsley. Yep, and Dr. Dang has a second. We will go into a private room, and we will be right back with you. Thank you for your patience.
Vote on executive session before we go in.
Yes, yes.
Yeah, can I ask a question real quick before we go?
Yes.
Two things. One, are there controlled substances put into these?
There are controlled substances that are put into. Yeah.
Who can make an adjustment, an on-hand adjustment?
An on-hand adjustment, as in like if they were doing like a cycle count?
Yeah.
Technically a nurse could do this, yes. But it would flag the pharmacy with a report saying that it was adjusted.
And of all the things I heard, that the features, I didn't hear that there's a camera. Is there any camera on this?
For like looking at the actual personnel that's pulling?
Right.
There is no camera that is pointing at the person yet.
There's no camera on a manual tackle box either, on a routine fishing box.
Okay, thank you.
Okay, I have a motion and I have a second. All those in favor?
Aye.
Aye. Any opposed? Okay. Okay, welcome back from executive session. I'll open it up to board members to continue with the.
Mr. President, may I ask a question?
Absolutely.
To whoever can answer this, where these machines are kept, depending on who goes to fill it, do they come in contact with patients, with the residents of these homes, or are they segregated away from patient rooms and where the patients congregate?
They would have to walk through the halls where the patients are at to get to whatever med room. That's normally what our nursing homes look like, but I couldn't give you an exact for this specific home.
Okay, thank you.
Yeah.
Were you asking where they're kept in the facilities, the machines themselves?
I'm just wondering, as pharmacy personnel come into these buildings to fill these machines, would they come in contact with patients? And I'm hearing that not necessarily. The patients may be in the hallway, but if the pharmacy personnel are wearing masks or are taking the appropriate precautions, they don't necessarily have the opportunity to transmit COVID from the outside to these patients, is the impression I'm getting from the answer you gave.
They should not be like in a patient room or anything like that. Yes.
Oh.
Mhm.
To me, it doesn't seem like we have the basis for the deviation. So I will make a motion to deny this request.
Second.
Okay, I have a motion and I have a second. Board member discussion before a vote. Okay. All those in favor?
Aye.
Aye.
Any opposed? Okay, thank you for your time today.
Yeah, thank you.
Thank you. Okay, board members, it is 12 o'clock. We probably have at least one more hour of material. I want to give a break for people to get something to eat and also return some phone calls if need be, and we'll reconvene at 1 o'clock. So we'll have a recess until 1 o'clock. Thank you. It is 1 o'clock and we are back from lunch, and I'll ask Dr. Gandhi to do a roll call.
Okay, Mr. Solari,
Here, sir.
Mr. Dang, Mr. Dang, Mr. Dang. Oh, get back to Mr. Dang there. Mr. Minkus. Mr. Dang, can you hear me? Kevin? Mr. Leyba? Mr. Leyba's in
Here.
Okay. Ms. Lehan?
Present.
Ms. Walmsley?
Here.
Mr. Tong? Here. Mr. Goodman?
Here.
Ms. Nair?
Here.
Okay, Mr. Dang.
Here, sir.
All right, there you go.
Here.
Mr. Minkus, there we go.
Sorry.
It's all right, buddy. All accounted for.
Okay, we're going to pick up at 7B and then say on that one.
Members of the board, after you had approved a consent agenda for consent agreements, there was an item on 7B that you had approved. We had notified the licensee, the applicant, that the board made a decision and that she would have to pay the civil penalty for $250 for failure to disclose in order to get her license, and her response back to board staff was, "I don't think so. Thanks." And so I'd like to have the board reconsider that consent agenda item 7B and deny, first rescind their approval for that agenda item, and then deny that consent agreement if you can, and then move the application for rediscussion at the February meeting and for possible denial of the application. Any questions I can answer for you?
I do have a question. Cam, you were cutting out. It's for, and Joe too. 7B is in boy.
7B as in boy, yes.
Thank you.
So again, the applicant doesn't intend to pay the civil penalty. So there's no point in keeping that consent agenda open. And
Don't we have language in there that if failed to sign, that it goes to hearing for revocation?
Yeah, we typically do. For some reason, it wasn't in this consent agreement. So we're going to have to revisit the application.
And actually, she did sign it. The board approved it. Now she's saying the day after the board approved that she will not comply with it. So that's
Okay.
why the thought was to rescind and then have the board reconsider the application.
I make a motion to rescind the consent.
Okay, I have a motion, and do I have a second?
I'll second.
I have a second by Ms. Lehan. All those in favor?
Aye.
Aye. Any opposed? Okay,
And then motion to review the application at the February meeting for denial, possible denial.
Do we need to go to hearing?
No, it's just an application review. Doesn't have to, it's not a.
I don't think you need a motion. I think staff can just put it on the agenda for February.
We'll do that.
Question is, what is the status of her license at this point? She does not have a license. This was an application. It was an application.
Correct.
Okay.
Correct.
I think under the terms of the order, once she paid, she would be issued. It didn't have a provision that if she didn't pay, it would be denied. And even had the 60 days to comply. So her telling you on the front end that she's not going to comply, it doesn't make sense to wait the 60 days, then to reconsider it. So the thought was to bring it back to you. So this way, the board hasn't taken action on the application yet because of the consent agreement. So the board would still have to review the application.
Okay, but she's not. But she can't work today in Arizona because she doesn't have a permit. Okay.
That's correct.
Sounds good. Thanks.
Okay. Well, see it back in February. Thank you, guys. You're muted, Mr. President.
29D, discussion, consideration, and possible action regarding Roderick A. Milner. Mr. Milner. Okay.
I don't see Mr. Milner in our meeting, Mr. President.
Thank you, Dr. Gandhi. Can you tell us what he is requesting as far as you know it and his communication with you?
So I don't think it's been real clear what he's requesting. The only thing he is saying that is that he's contesting the consent agreement. He does not wish to sign the consent agreement regarding case 19-0051. And I think staff was hoping that we would gain more insight during this meeting.
Is our option to move to hearing? He's contesting, and I think that would be a chance for him to explain his contesting.
Did we hear from him after we noticed him of the meeting?
On page 3732 of 3732 of the board book, you can see what Mr. Milner submitted. This was on September 24th, 2020. This was in response to the consent agreement.
What page was that, Elizabeth?
3732.
To answer Jean's question, yes, we did. I got a thank you.
Thanks, Jennifer.
You're welcome.
So you could just move it to hearing because it appears he's not interested in signing the consent agreement. You could table it and we'll try to contact him and see if he wants to come in February to provide us more detail. Maybe just more expeditious to go to hearing.
Well, if the hearing gets set, it would probably be set for February, in which case he can come in and talk to them during the hearing.
I make a motion to move Mr. Roderick A. Milner to hearing.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Okay, thank you. 29E, discussion and consideration and possible action regarding Farbod Melamed. Mr. Melamed, welcome to the meeting, and would you state your name for the...
Yes, hi, Farbod Melamed here. You guys could hear me well?
Yes, I can hear you. Did you state your name for the record? You cut out, I'm sorry.
Oh, I'm sorry, Farbod, excuse me, Farbod Melamed.
Okay, welcome, Mr. Melamed. Board staff, could I get you to give a, well, I don't think we do. Mr. Melamed, what are you here before us today? What is your request?
My request is in regard to the consent agreement and order for probation that I signed back in June of 2019. My probation period in California is over. I complied with all the terms and conditions, and I'm requesting the Arizona board to remove the probation as well.
Okay, thank you. Board members, do you have questions?
Mr. President.
Yes.
Sir, has the issue with Oregon and Kentucky also been resolved?
With Oregon, it has. I got a letter from them. I have not heard from Kentucky yet. I sent them the same notice I sent to you guys. I haven't heard from them yet.
Thank you, sir. Mr. President, I don't see any reason why we need to hold this up. He's complied with the terms of his consent agreement. I'm willing to make the motion if nobody has any questions.
Thank you, Mr. Slurry.
Then I will make the motion to grant him his request to terminate his probation.
Second.
I have a motion by Mr. Slurry and a second by Mr. Minkus. All those in favor? Aye. Any opposed? Okay, thank you for your time today.
Thank you all. I appreciate your time on this matter. Have a great day.
Take care. You too. 29F, Nathan Duke.
For the record, sir, I'm recused from
take
this case.
Take yourself off of mute, Mr. Duke. And Mr. Slurry, did I hear a recusal?
Correct, sir.
Okay, thank you. Welcome to the meeting, Mr. Duke. Would you state your name for the record?
Nathan J. Duke.
Okay, thank you. And Mr. Duke, what brings you before the board today?
Thank you, Mr. President and members of the board. The reason I'm here today is to request that my suspension be lifted and turned into a probation for the next 4.5 years.
Okay. Board members, do you have questions for Mr. Duke? There is a letter of support by Dr. Fine in the reading.
Mr. President, if there's no questions, given Papa's support in his recovery and his compliance with the terms of his substance use monitoring, I would make a motion to approve lifting the suspension and moving to probation.
Goodman, second.
Thank you. Ms. Walmsley with a motion, Mr. Goodman with a second. All those in favor?
Aye.
Aye. Any opposed? Okay, thank you for your time today, Mr. Duke.
Thank you, sir.
29G, discussion and consideration and possible action regarding Todd Coakley. I see Mr. Coakley in the room, but I think he's on mute.
Does that do it there?
There you go. You got it. Welcome to the meeting. If you'd state your name for the record, please.
Todd Urban Coakley.
Okay. Mr. Coakley, will you tell us a little bit about your request before the board today?
I've been in Papa for over 5 years, and I'm up in January, but I was coming before you now so I could take care of this so I wouldn't have to wait till the next board meeting.
Okay, understand. And Ms. Fine, I see you there as well. I see a letter of support. And board members, do you have any questions for Mr. Coakley?
Mr. President, I don't have any questions, but if there's none, I'm willing to make the motion.
Okay, thank you.
Then I congratulate him on completing his 5 years, and I make a motion to remove his probation.
And would that be done in January?
Yes, at the conclusion of the 5 years, when he's due, we can terminate his probation and return his license to a standard status.
Okay, I have a motion. Do I have a second?
Second. I'll second that.
I have a second by Mr. Minkus. All those in favor?
Aye.
Aye.
Any opposed? Okay. Moving right along to 29H, Mr. Paul Gurvich.
Present.
Okay, Mr. Gurvich, if you'd state your name for the record, please.
Hello, my name is Paul Gurvich. Thank you for your time.
Thank you for coming today. Mr. Gurvich, what is your request before the board today?
Requesting to lift the suspension status from my license.
Thank you. Board members, on page 2, there's a letter of support from Dr. Fine as well. I'll open it up for any questions you may have.
Seeing that there's no questions, I'll make a motion to end the suspension and go to probation. Oh, excuse me. In the suspension and probation at this point?
In the suspension and start probation.
Thank you. Thank you. I misread that. Thank you. In
No
suspension and start probation.
Okay, I have a motion by Ms. Snare.
I'll second, sir.
I have a second by Mr. Solari. All those in favor?
Aye.
Aye. Any opposed? Thank you.
Yes.
29I, this is discussion, consideration, and possible action regarding the request for Marshall B. Ketchum University College of Pharmacy. I would ask board staff to tee up this communication.
Okay, Mr. President. There is a list of pharmacy schools across the country that are accredited, and we have a list of those. As new pharmacy schools get introduced, they have to go through a number of years, have a graduating class, and show that the education provided to these students is of good value, and the future pharmacists add value to the profession and to public health. Marshall Ketchum hasn't gone through that process yet, but they are a pharmacy school, and our language states that the Board of Pharmacy accepts and licenses folks from accredited schools or through board approval. So we're asking here to approve Marshall B. Ketchum as a valid pharmacy school so that we can issue intern licenses to their students.
Okay, thank you. I'll open it up to board members' questions or discussion.
Do we have any representatives from them here? Or is
No, we
that
don't.
the board's request, the board staff's request?
It's their request and our request at the same time. We are getting interns applying that want to do internship in our state, but we're not allowed to issue licenses until you guys approve it.
We've done this before for other schools, the new schools.
It's been a while, but that's, yes, the statute is written that way to allow you to approve pharmacy schools.
Board members, I'd make a motion to approve the request.
Second.
I have a second by Mr. Dang. All those in favor?
Aye.
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 Any opposed? Okay. That takes us to 30, the Executive Director report.
Thank you, Mr. President. First thing on my report I want to discuss is the 2020 Employee Engagement Survey conducted by the state. And if you take a look at it, it does compare us, our agency, compared to the overall participants in the state. It looks like we do slightly better than the overall state as a whole. And year after year, we've continued to improve. We do have that light green that we'll work on, but it looks like we're taking care of our employees the way we should be. Don't know if you had any questions on that.
Board members?
No question, more comment. Good to see improvement continuing through the years and the number of these categories. So thank you.
I agree.
The next agenda I wanted to discuss, and this really came to light as of recent, is regarding pharmacists and NPI numbers. A lot of pharmacists do have NPI numbers today. We don't capture that information on our application and the profiles that we keep for pharmacists. So we need your permission to be able to modify our application to incorporate capturing NPI numbers. NPI obviously is a unique number to healthcare providers and could facilitate in billing for services in the future. So if we capture that, not necessarily we're going to be involved with the billing, but we do partner with Access and other state agencies that may want that information for their database, and it'd be readily available if we can capture it.
Mr. Gandhi, not all pharmacists have an MPI number. You're not requiring everyone to go get one.
That's up for discussion. It's not, it doesn't cost anything to get an NPI number. You just have to register with the National Registry.
Now, Dr. Gandhi, expand again on why this is before us. What is behind requesting that pharmacists report by NPI?
As pharmacists' roles increase, giving immunization, working under protocols given by the doctor, and stuff like that, there's a limitation on billings that a pharmacist can do to provide those services. We've been asked by Access whether we store that information or not. And unfortunately, we have to tell them we don't. Then the request was, well, can you? And so Access is kind of what stirred that discussion with me to put it on the agenda.
Would the NPI bleed over into tracking of the PMP?
No, those are two different databases and they're not integrated.
Okay.
Would this be part of their online profile?
It would be part of the online profile, yes.
Given the bad experiences we've had in the past with databases and other people requesting access to them, I don't, is there a reason the Board of Pharmacy needs to have this? Is it important to what the board does to provide, to have this information on file?
Well, the NPI number is kind of like a DA registration for prescribers and pharmacies. It's a unique number. I can look up an NPI number. It's not necessarily confidential. So if you have one, I can just go to National Registry and look it up. So there is a database, but it's a national database that houses it, and it's not readily available for friendly use.
But do we, as a board, do we need this number for your office to do their job, office staff to do their job? Do they need this number?
No, it's not a requirement for us to use it for any other reason. But I could add, as we granulate the PMP data some more, today pharmacists are required to use the PMP, but to narrow down which pharmacists use it, it's difficult to do because it's the pharmacy that's registered with the PMP. And as we granulate the PMP down further, it may become of value in the future for us.
So Cam, you said that it's a number that the National Register has and publishes.
Yes.
So it's not a number that an unscrupulous person could obtain and then commit some kind of fraud.
They're public right now. They're public record right now.
They're public right now.
I don't quite understand, Ms. Galvin, to your point, what is the nature of the request? Is it because Arizona DHS has requested to do this? What will this give you to Mo's point as well?
Access has requested it.
Okay, Access.
Yes.
But why?
Because I think Access is billing, and I think Kelly is also involved with the conversation with Access. I'm not sure if she's on, or she can add more content to this discussion, but it does allow Access to have that information and then to set up in their database reimbursement for pharmacists or pharmacies.
Ms. Fine, would you mind making a statement if you would like?
Yes, please. Thank you. Well, it was supposed to be January 1st of this year. Access pushed it back a little bit till June to give everybody a little bit more time, but there's new regulations that are going into effect that pertain to the ACA that Access is implementing. It's called ROPA, referring, ordering, rendering, and I don't remember the exact terminology, but it basically requires any provider that's billing services to our state Medicaid to be registered with them as a provider. Now, because we're not officially recognized with Part B, there's kind of a workaround that Access is doing right now for pharmacists. But come that deadline, if the MCO plans don't have the pharmacist names and information, when we go and bill things where we are listed as the prescriber, best example would be for vaccines where we put our name there and MPI, those claims will be rejected. And so what the conversations have been, is there an easier way for Access to obtain this information? And originally it was, well, does the board collect it? And currently you guys do not. But how can we create a process or a system that would make it easy to keep these lists updated without having to? Right now what they're doing is going to all the employers, having them put together spreadsheets, and we're trying to collect it on behalf of some of the independent pharmacies. But then there's the issue of, well, what happens when new people move into the state or new people get trained? How do we ensure that those lists are updated? And so this would apply to other services that we may in the future be able to bill for, tobacco cessation services, other types of services that we may be able to bill Access for. So that's where I think the ask would be, is just, is there a way to collect it on behalf of the pharmacists in the state? And then from what I understand, CMS does require entities that are HIPAA covered entities to have MPIs. Pharmacists are on there. I don't know all the nuances. I do have a link I can share with Cam to disseminate to everybody. But from my understanding that everyone is supposed to have one. It is free. It's really easy to get one, but I don't know if there's any other questions on that.
Thank you. Board members?
I have one question for Ms. Fine. So Ms. Fine, you would be supportive of this request to add this to the application?
I think it would be very helpful, yes.
Mr. President, given our past experience with who has access to our data and whether they should or not, I'm reluctant to add more information to our databases. At first, of course, you always start with it's free. At first, of course, you start with it's optional, then it becomes mandatory, then the fee comes added on, then you add it to the databases and all kinds of governmental entities will want access to it. And I just don't want to go there. This doesn't improve patient care. If payers and those who want to get paid want to have this information between them, let them work it out. But I don't see why the Board of Pharmacy needs to get involved. I don't see why the PMP needs to have this information. It's not going to help us down the road. I don't see when somebody can make a real case for it, I would support it. But at this point, I don't see why we need to go to the trouble.
President, this is Goodman, if I may.
Yes, absolutely.
So coming from a world where all the people that are professionals that I work with have an MPI, basically, I see where Access is coming from on how they're trying to track things. I think given what I understand about what pharmacists want and the ability to do things like injections and other billable services, that with those types of goals, this would be a nice thing to do, one for Access, but also for pharmacists in Arizona so that they can choose to become more aware. We could put it on the form as a piece of information that would then get them to research it more, not make it even required, just make it part of the form so that they're aware to find out more. And so that's where I would take it, because it's often through government that we realize that things are changing and the world of pharmacy is changing, that you're not going to be given any injections at Costco or Walgreens as a pharmacist if Access won't pay you. So that's my take on it.
Good comments, Mr. Goodman. I tend to believe with and support your opinion and Ms. Fine's opinion on this as well. I would say that right now in industry, if you work in a community pharmacy, you have an NPI number already. And as Dr. Gandhi has stated, that information is publicly available right now with a simple search. That's my opinion on it.
And to address Mr. Solari's concern, is that it doesn't have to be a mandatory field, it can be an optional field. So that could alleviate your concern, Mr. Solari.
Not at all. I've seen this before. You start with optional, then it becomes mandatory, then a fee gets added on, then all kinds of people have access to it. We've been here before. We've seen this with the PMP, and I just don't want to go down this road just to end up with giving our information to other government agencies.
I agree with Mr. Goodman and Mr. Leyba with this case. I really feel like this is something that is a benefit to both for our licensees to aid them in credentialing with Access. And since this is a request from another state agency, I do think it's something worth considering. The other thing I think that we need to keep in mind is in the event that a pharmacist is not credentialed with Access, and my understanding with what is going to happen with ROPA, that would stop service if the pharmacist did not have the credential with Access. So there could be a potential downstream effect for patients later in June if the pharmacist didn't have the appropriate credentials, if they weren't able to bill Access. So it could stop access for patients to have their normal prescriptions filled. And I certainly would not want to see that for our consumers, especially if there's a way that we can collect this information on a voluntary basis. So I would be in support of this.
Any other board members before I ask Dr. Gandhi what he wants? Okay, what do you want? Do you need a motion to pursue putting this on or not, putting it on an application, NPI number? And is that what you're requesting?
Yes, I would need board approval to modify the application and the profile.
Any follow-up discussion or questions, board members? Okay, I'll entertain a motion.
I'll make a motion to direct board staff to add a field for NPI for pharmacists on the application and on the personal profiles.
Okay, thank you. Any clarification needed before we move
Is
on to
that
a second?
voluntary or mandatory?
I would like for it to be voluntary.
Goodman seconds.
Okay, I have a motion. I have a second. Hearing that there may be some differences, could we do a roll call? Is that you're going to say, Ms. Galvin?
Yes.
Okay, Mr. Solari,
Nay.
Mr. Dang,
Nay.
Mr. Minkus,
Aye.
Mr. Leyba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong. I'm sorry, Mr. Tong.
Aye.
Mr. Goodman,
Yes.
Ms. Nair.
Aye.
Okay, motion carries.
7-2.
Okay, Mr. President, the third agenda item, we've already discussed the new board members. The next one on my list is legislation is now coming up, and every year I ask vice chair and chair to participate in discussion as legislation gets heated and there's new things introduced, to be able to reach out to chair and vice chair for guidance and or approval. If obviously the topic is involve the full board, the chair and vice chair would direct us to direct that to the full board. So my ask is that I'm able to reach out to chair and vice chair for guidance and or approval to move forward on legislative changes that come forward during the session.
Okay, thank you. Board members, questions for the executive director on his request?
I thought we'd already made this directive, or whatever the word would be.
We did. It's just I'd like to revisit it annually. Just make sure we have that.
You're on mute.
I'm sorry, something that we visited annually just to get permission from the full board to allow chair and vice chair to work with me during the legislative session. It's an annual ask.
I'd like to make a motion to allow the chair and vice chair to work with board staff during legislative
Second.
discussions.
Okay, I have a motion. I have a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, thank you.
The next ask I have for the board is we typically, when we have concern about an application and we need more direction on whether it needs full board appearance or whether the chair and vice chair can approve it, we have made recommendations, presented to the board, and then taken action on those licenses. Many times, I don't know of a single time that the board has denied the recommendation for an application. And so the ask is, once chair and vice chair approves an application to be open with no action taken against it, to be allowed to open, and so these folks can either start operating or start practicing prior to the full board accepting the recommendation. Does that make sense?
I don't know if I like that. I trust the chair and vice chair, but I still would want to see it. Personal feeling. I would like to be able to discuss it, just have the option, sometimes just to know where it came from, even if I don't disagree with it.
I agree with Ms. Nair.
President, I also agree with Kristen.
Dr. Gunny, could you give us an example of what you're referring to?
I think just an example during this board meeting, we've had cases that were fairly dated, that an applicant had a criminal activity many years ago. And granted, it may have been a felony or something that may have required, it may be drug related. But again, it happened 10 plus years ago where chair and vice chair felt that, these people haven't gotten in trouble since. Let's move to approve and take no action. I think you've seen several examples of that during this board meeting. It basically just delays these folks from working. It might be, let's say for instance, I have an application that just came in right now. We're going to meet with Joe and Lori maybe in a month, and then the board meeting is in another month after that. So it kind of delays that process from these folks either seeking an opportunity to work, or if it's a business, it prevents them from operating for another month because of something that we as board staff don't have the resources to make a decision on it or the ability, but vice chair and chair are comfortable with moving that application forward. And I can only reference the examples from this board meeting.
Dr. Gandhi, this is Kevin. I do see the urgency for those type of situations, but ultimately, patient safety to me is more important than that. So not to say that I don't trust the vice chair and the chair, but I think these type of decisions that we have a collective agreement from the board standpoint, and that would be better for the safety of the Arizona people.
I agree. I think that we started having chair and vice chair to look at them because it does speed up our board meetings, but I don't think it's wise to speed up the process. It's, government unfortunately is slow, and sometimes that's deliberate, so it's thought through. And I'm not trying to prolong anyone's process, but I think it's good that we have a full review.
Okay. Having heard that, Ms. Snare, would you like to make a motion?
My motion is that we do not accept this proposal, having chair and vice chair make decisions before full board review.
Second.
Okay, I have a motion, I have a second. Any other discussion before a vote? Okay, all those in favor?
Aye.
Aye. Any opposed? Okay. Dr. Gandhi?
That has to be reported to the national database, Mr. President.
I'm sorry?
Just kidding. I'm kidding.
I didn't hear you.
That's all right. It wasn't a good joke. The next agenda item, guys, is I would like board's permission, and this is something that came up during our Auditor General review. I'd like the board's permission to put together a stakeholder meeting to discuss fingerprint clearance cards requirement during renewal. We can dive into this conversation a little more, but I think Mr. Leyba and Ms. Walmsley had an opportunity to sit in on our meeting with the auditors, and I won't say it was a pleasant meeting, but one of their asks is to have all licensees have a fingerprint clearance card going forward, as long as they hold a license with us.
Dr. Gandy, some of us older pharmacists were exempted from having a fingerprint clearance card. Would we be required now? We were grandfathered out. Are we going to be required to go back and get one?
Well, that's what I want to discuss with the stakeholders. So if the stakeholder comes back and makes a recommendation that, yes, it's a good idea, then nobody would be grandfathered in. That is the ask from the Auditor General for us to discuss it.
But we're under no obligation to grant that, right?
We're just going to have a stakeholder meeting.
We're just going to have a stakeholder meeting.
again, here we go again. First you have the meeting, then you approve it, then everybody has to go get a fingerprint clearance card, then there's another fee, another tax, another government obstacle and bureaucracy in the way of people doing their jobs. And I just don't see the value to this.
Right.
I do. I think that at least the discussion, there's value, because first it's been asked of us from the government, and it's regarding safety. And that's our main focus. So I don't know that it should or shouldn't happen, but discussion I think is fair.
The Auditor General is not the government, but once you go down the road, it just, that's how things snowball into additional bureaucracy, additional fees, additional taxes. And it's just, there's no reason to go there. If the pharmacist or a technician has been practicing for 20 something years and they didn't need a fingerprints clearance card, then why make him go get one, pay a fee, go through the government bureaucracy, get fingerprinted? It just unnecessary government intrusion into people's lives. Leave people alone.
And I have a question for Dr. Gandhi. So this fingerprinting requirement, does it apply to all the renewal of the pharmacist license for all states or just Arizona? The reason I ask is, the reason I ask is because there's many of us who do have multiple licenses. And imagine if when it's time to renew our licenses, like for me as an example, I have to do for Connecticut, for Arizona, and from other state, Texas, that I have. It's going to be a huge burden for me, but I can speak to other pharmacists who have multiple licenses too, that it's going to be a huge burden. And I don't see the true purpose that it serves, because if there's anything wrong with my license, NABP would know, and NABP would report my unlawful actions to all the states that I'm licensed in.
Well, I can't speak, Mr. Dang, I can't speak to the requirements of the other states. This would be a discussion just for Arizona licensed individuals, pharmacists, technicians that are licensed with us. So, yeah, I don't know what to say, answer your question.
I guess my point is, if NABP supports this action, then I think we just have to go with their suggestion. But if NABP doesn't really enforce it or doesn't recommend it, and out of the 50 states, Arizona become the first state that require fingerprinting for all the renewals, my fear is more and more states gonna follow Arizona, and at the end of the day, it's gonna be a huge burden for all of us who are practicing in multiple states.
So here's the nuts and bolts of the conversation. This is basically an ask for stakeholder meeting, and if the stakeholder is not in favor of doing the fingerprints for people that have been licensed forever, then that's the recommendation we take to the board. If the board is in agreement to not doing the FCC cards, then at least we've fulfilled our obligation that the Auditor General is asking us. And the dirty part about this whole thing is that if we don't go up this road and have a stakeholder discussion, then somebody else may make a decision for us, and we don't have the opportunity to chime in at the time.
Mr. Gandhi, I think that that was well put at the end, and I would be in support of having the stakeholder meeting, although I am leaning towards Mr. Solari's comments on this. I do think that having a conversation like Ms. Snare says in the aspect of patient care is something that we could do and is good for a board. Doesn't mean that anything will come of that. It means you gather the facts, you get educated, and it reinforces your belief or it changes that. So I would be in favor of a stakeholder meeting.
And Mr. President, I echo your comments. We've also expressed our concern with the Auditor General, stating that basically if a bad pharmacist is out there, we'll know about it. That's not a problem. But having a burden like this, we're not in favor of it ourselves from board staff's perspective. So we've already shared that, but this recommendation still came down from them to the legislators. And it's better to be driving in a driver's seat, driving the car basically, than being a passenger, making having decisions made without our input.
President. May I ask Dr. Gandhi, how do you assemble a stakeholders meeting?
If you guys leave that up to me, I can assemble. Obviously, we have AZPA that's usually at the table. We have some, we got Walgreens also, Safeway. We got some industry folks that could get involved. Mr. Solar, if you want to chair it, that would be up to Mr. President to chair or assign that to you. So we can get folks together in a room.
May I speak, Mr. President?
Yes.
I disagree with the list of stakeholders that Dr. Gandhi presented. Why is AZPA or Walgreens or any of these people, how are they stakeholders? They don't have to be fingerprinted. The people that have to be fingerprinted have to be the stakeholders here. And those are pharmacists, technicians, tech trainees, pharmacy interns. I don't see a reason to have industry or the association involved here. They don't have to do anything here.
Agree.
Then we would take those recommendations and invite those people if you know those pharmacists that want to participate in the stakeholders.
And I'm happy to chair this if we decide to go there. At this point, I don't favor even getting anybody together, because once you put a committee or a task force stakeholder meeting together, it becomes sort of their job to make this move forward, as opposed to, you know, the momentum is to move it forward as opposed to not do anything. And so anyway, if we're going forward with this and the vote occurs and we decide to go forward, I'm happy to participate, but I don't think the stakeholders are who Dr. Gandhi proposed. I disagree with that list.
And Mr. Solari, I would recommend that that is your opinion as well, and there are other opinions. And it would also be my opinion that you do not chair that stakeholder task force, that it would be Ms. Snare, as she is more of a looking for this as an educational component, and I think would serve as chair of that task force if we go forward in a good manner.
So I didn't say I wanted to chair it. I said I would be willing to participate in it.
Having said that, board members, any other discussion, or I'll entertain a motion?
I would also like to participate too.
Well, since nobody's making a motion, I will make a motion to deny putting this stakeholder meeting together.
Ms. Nair already made a motion.
Oh, sorry.
I just said that I would be for moving forward.
Oh, okay. I thought you made a motion. I'm sorry.
Yeah.
Do you want me to make, well, okay.
You
Then
just did make a motion.
I will make the motion to deny.
Is there, it has to be second.
Second.
I have a motion and I have a second. And let's do a roll call, please.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba?
No.
Ms. Lehan?
No.
Ms. Walmsley?
No.
Mr. Tong?
No.
Mr. Goodman?
Abstain.
Ms. Nair?
Okay.
It's 5-3, 1 abstain.
Okay. Board members, I would ask that the director and deputy director form the task force as well. Representation from the community on this one versus people volunteering for it. My recommendation again would be Ms. Snare to chair that meeting, and I will defer that to legal counsel and the executive director on how to proceed.
Is that your motion?
I'm kind of filling it out right now, Ms. Snare, on what they need. My motion would be for you to chair it. My opinion would be for the executive director and deputy director to be the ones who help to identify task force members. Ms. Galvin, any kind of guidance you can help us get out here?
I'll work with staff and we will come up. I think you've as chair kind of given the directive that you would like to see Ms. Snare chair it, and then I'll work with Cam and Jennifer to work out the details with staff.
Okay, thank you.
Do we need a motion for them to approve putting together the stakeholder group? I know we just had a motion fail on denying doing that. Do we need a?
Oh, you're right. Yes.
I make a motion to put together a stakeholder group to discuss the fingerprint clearance cards.
I'll second. And just to clarify my second, I am in support of exploring this, not necessarily making it a requirement, but I don't think there's anything wrong with having the conversation.
Okay, I have a motion, I have a second. Council, any clarification, or board staff, any clarification before roll call?
May I ask a question,
Yes.
Mr. President? So the chairperson for this stakeholder meeting, does it have to be a board member? In my mind, I think the best person to chair this would be Dr. Gandhi, just because he works with all parties involved. He works with the corporate staff, the techs, and the board members. So if Dr. Gandhi doesn't mind, I think it will be more effective if he could chair this meeting, because the directive seems like the directive actually came from the governor's office, if I'm right.
The Auditor General's office.
The Auditor General, yes. So who's knowing about them more than you do, Dr. Gandhi? So I think it would be best if you could chair it and lead us through this meeting.
And Dr. Dang, that could be viewed as a negative as well. I understand what you're saying. I would like Mr. Hartgraves and Ms. Galvin to comment on that. Dr. Gandhi doesn't have a vote on this board, and it makes me wonder if he should be the one leading that meeting, but I'll defer to legal counsel.
Typically, the executive director or staff members facilitate the stakeholders meeting or any committee meeting. They staff it. They are not actually members for that reason, that they don't have a voting position. And that could be viewed as having staff become too entangled in the policy making versus carrying out the policy of the board or the committee.
Okay, thank you. Okay, so help me, where were we? We had Ms. Snare, did you make a motion? Ms. Walmsley may had a second?
Yes.
Yes.
Okay, and Dr. Gandhi?
Mr. Solari?
Nay.
Mr. Dang?
Aye.
Mr. Minkus?
Nay.
Mr. Leyba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Abstain.
Ms. Nair?
Aye.
Okay, ayes have it, Mr. President.
Okay, thank you.
Now, the next topic of discussion is a substantive policy in your book, which basically supports the executive director from taking action or no action on cases that pertain to what's itemized in your book. If there's anything I'm missing in that list under number 2, please let me know. We can add it to it.
Okay, Mr. Gandhi, I'm not following you. What are you requesting here?
An approval of the substantive policy. So anything that's related to payment or pricing, customer service related issues, prescriptions not filled timely, professional judgment to address a prescription order, medication not in stock, back order, otherwise not immediately available, anonymous complaints with insufficient information to conduct an investigation against an individual or entity over which the board has no jurisdiction.
These are all the things you already screen out.
Correct.
So this is Goodman. To clarify, is this a change or a continuation of past responsibility with the executive director?
This is what we've been doing. This is just putting it down on paper so that it can be posted and everybody knows why and what the executive director's responsibility is.
Mr. President, may I? So I agree with everything on the list except item 2E. I would like the item 2E reworded. And the one I object to is the medication not in stock. The back order I'm okay with, or otherwise not immediately available, I don't agree with that. Sometimes some pharmacies keep low inventories of expensive drugs and it causes patients to make multiple visits to get one prescription filled. The quantity is 30, the pharmacy keeps 10 on hand. They have to keep coming every 10 days to get it filled. And so I just want to make sure it's 2E back orders only. If it's a manufacturer back order, I'm okay with it. But if a pharmacy is intentionally keeping some stock low because the item is expensive, I don't agree with that.
Mr. Gandhi, for the record, will you direct us where you're at exactly on the agenda?
I'm on page 3819.
That's the same page I'm commenting on, item 2E. I just want 2E to be back orders only, not medication not in stock, because sometimes that's done intentionally to keep inventory costs low.
And Mo, I don't see how is that your business if inventory costs are kept low in a business?
To me, it's a patient service issue. If an inventory level is low and you get a partial fill on your prescription, you have to keep coming into the pharmacy. Some people can't do that easily. They have to be driven, or they have mobility issues. In these times of COVID, a lot of elderly patients don't want to get out of their house if they don't have to. So it's important for them to get a full prescription each time they go to the pharmacy, so they don't have to keep taking multiple visits to the pharmacy and keep getting partial quantities.
But Mr. Solari, what violation of statute would that be?
I'm not sure that it's a violation of statute, but it is poor service and it is inconvenient for patients. And I just don't want that to be something that we dismiss without reviewing. In this case, what you're asking is we want to be able to dismiss these service issues. And sometimes service issues are important. They shouldn't be necessarily dismissed. And I don't want to encourage pharmacies to do partial fills. I want them to be able to, I want patients to get their prescriptions as much as possible on one visit. So I don't want them to be dismissed without review.
But we couldn't take action. We couldn't take action on it anyway if there wasn't a violation of law. So why would we care?
Yes.
Let me unmute here. Mr. Solari, you still have the opportunity to ratify our decisions. So you're still reviewing them, kind of like what you did during this meeting. There were 48 cases that we took action behind the scenes that you guys ratified. So if you identify a matter that fell into a concern that you had, you can actually pull it out for further discussion. So it still doesn't take that ability away from you.
Well, I would rather have it modified just to say back orders, not say medication not in stock or not otherwise immediately available. But if you are correct in that it doesn't really.
I understand your concern, Mr. Solari, but then from a board staff perspective, when we present a complaint to you, we usually have violations outlined at the bottom of those complaints, and we have no violations that we can attach to this kind of case. So to present it to you is almost pointless.
I get your point very well.
Okay, Mr. Gunny, are you looking for a reaffirmation of what you're doing with a motion?
Yes, I am. And if I'm missing anything on that list, please let me know so we can add to it and then post it.
I would make a motion to accept the substantive policy as outlined in 30A.
Second.
We have a motion and a second by Dr. Dang. All those in favor?
Aye.
Aye. Any opposed? Okay.
The next agenda item, Mr. President, is I wanted to draw to your attention the number of applications that we get in our agency. On an annual basis, we are processing anywhere from 3,000 to 4,000 technician trainee applications annually. And out of 3,000 to 4,000 technicians, about at least 2/3 of them come incomplete, which is very exhausting and time consuming because now we're chasing that applicant around to get fingerprint clearance cards or criminal history checks and all that other stuff. Which then the 1/3 of the population suffers because the old theory applies. You're spending 80% of your time on 20% of the population. And then, there's people that get neglected and their application process slows down and so forth. So our ask is something for you to think about is we have an online application process. And with the application process, you're to upload your fingerprint clearance card, high school diploma, or any required documents for that application. I'd like to make those fields mandatory so that they cannot apply if they haven't uploaded their fingerprint clearance card or their high school diploma or something, and so they can't process it. So we're getting, in essence, more complete applications that we can process quicker than trying to chase information around after the fact, delaying good applicants that are already in the system. So I wanted to open that up for discussion. I hope I was kind of clear in explaining our situation behind the scenes.
So just to confirm, your ask is to put a mechanism isn't complete. It doesn't allow the applicant to electronically submit.
They have to upload all their information before they can submit, yes.
Okay, and you're not asking for any new information. You're just asking for a complete application.
Correct.
And it would tell the applicant that they were missing something and what they were missing, and they would know that their application wasn't stuck in limbo. They would know what needed to be added.
They just wouldn't be able to submit it if they don't upload the necessary required information.
But it would be clear to the applicant what's missing and what would be required in order for it to be processed.
Correct.
Okay.
Dr. Gandy, Mr. President, may I ask
Yes.
you? Somebody from the staff still reviews this, right? So for example, it asks me to upload my high school diploma and I just scan in a blank piece of paper. Somebody reviews it to make sure it's actually my high school diploma and not just the.
Correct.
Okay.
Correct.
I make a motion to approve the request.
I'll second that, sir.
Okay, I have a motion and I have a second. Any other discussion before vote? All those in favor?
Aye.
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 Any opposed? Okay, thank you.
The last thing on my list, Mr. President, is staffing update. As you know, we're going through a lot of transition in our agency right now. We have a new deputy in place, and I'm not sure if she's in a position to introduce herself, but if she can take a minute and introduce herself, or she will, I'm sorry, at her next report, she can do that. But we do have a new deputy, Jennifer Gilnavong, who's been with us for almost 2 months now and feeling her way around the situation. We also have other changes coming up. Our licensing administrator for pharmacists and intern is retiring. Her last day is next Thursday, matter of fact. So we'll be shifting staff around to fill that position. At the end of January, we have a compliance officer that's been with us for some time, Tom Peterson, who is also retiring at the end of January. And so we're going through some changes here. But of course, we wish everybody well in their transition. Just recently, about a month ago, we had Rob Dabrowski, who took on another opportunity with the state, not in the IT position role, but in a different capacity. So we wished him well as well. So again, agencies continue to transform and will continue to grow and be bigger and better as we move forward.
Thank you for that. Any questions for Mr. Gandhi before we have a 10-minute break and then reconvene for the rest of the meeting?
No, just one comment though, Mr. Leyba. Want to say thank you to the members of the staff that are retiring after their many years of service. Really appreciate everything that you've done for the board and for the citizens of Arizona. Tom worked with you most directly, so wish you all the best in your retirement since we won't see you before the next meeting.
Absolutely. Well done.
Agreed. Yeah.
Any other comments? Okay, let's take a 10-minute break and then come back and finish up. Hey, welcome back, everyone. We will pick up on agenda item 30B with the Deputy Director. And before we start, Jennifer, it's been great having you. You're very organized. Your approach is very thought and sound. And when I bring that to your attention, your comment that you come back with is Elizabeth has been such a great teacher and everybody here at the board staff has been such a support for you. And I think that shows a lot about character. So I want to really welcome you and let you know that I think that you're doing a great job. And I'm very Happy to move forward with you in position and very confident in your abilities. And with that, I will open it up for you to enter your report and maybe introduce yourself a little bit.
Sure. Thank you, President Leyba. I appreciate that. Hello, everyone. I've met most of you in person, but for those that I've only met virtually, it is a pleasure to meet you and to work with you. My name is Jennifer Gelnavong. I've been a pharmacist for 13 years now, a little over 13 years. I originally came from professional practice in the community and acute care space, as well as a clinical practice as well. I've also come from academia and most recently corporate ethics and compliance with a focus in pharmacy regulatory compliance. So I'm very happy to be here and part of this really great team.
That's great. Wonderful. Well, again, welcome board members. I don't know if you have anything to say, but we're really glad to have you. Okay. We will pick up with your first agenda item.
Okay. So the first agenda item is continuing education audits. So our board staff conduct routine continuing education audits for compliance with Arizona CE requirements. These statutes and rules are included in the board book for your reference. Also included are minutes from the November 2015 board meeting, which discusses fines and additional CE requirements for licensees who have not met the minimum CE requirements. So the CE audits conducted by board staff for licensees who renewed in 2019 have identified several instances in which minimum CE requirements were actually fulfilled, meaning 20 hours for technicians and 30 hours for pharmacists. However, some of these were delinquent in one or more categories of CE applicable to the licensee. So for example, law, opioid-related or immunization CE. I've provided a redacted audit sample for your reference. They are all technician examples. So the first ask is that board staff is seeking some guidance or perhaps a motion with respect to how these particular scenarios should be addressed with the licensee. I have
a comment. They were almost all or all opioid related CEs. Is that correct?
There were opioid related as well as law.
I'm just wondering if we should give some type of cushion since that was a new requirement or a change in requirements. Do we typically give like a year grace period or anything like that? Or is that time up? I don't know. What
it might be up. It
Yeah.
really might be up. I think you bring forward a very interesting topic, and board members, this is something that the licensee has come through with the right number, but not the right type of CE. So
Right.
they're asking for what do we do in those circumstances. So again, you're not dealing with somebody who's just negated to do CE or somebody who has tried and they've come in with 14 hours versus 20 hours. They're over the limit. They've just not done the right CEs. It tells me that that individual is not trying to do something. They're trying to get to that number and abide by the rules, but they may not know all the rules. To Kristen's point with this first go around and to a statement that was brought up earlier is with the law and opioid, there is a lot of opioid law out there, and I would ask somebody who knows a little bit more to expand on it that may not be dialed in for reporting purposes. Renewal 2-year cycle could be a little bit off. I know, Ms. Snare, to your point, it's probably been a year would be my guess, but we may need one more understanding cycle as long as somebody has done the right number. And I'm not saying that's a motion, I'm just putting it out there that, you know, I'm with Kevin, the number of CE that you do and the type of CE you do, it's very important, and we should hold people accountable to the number of CE. But what we would have here is just not the right type, and I'll open it up at that.
Mr. President.
Yes.
Go ahead.
Madam Deputy Director, how many individuals are involved here during your audit? How many did you hit? And do you have an actual number that are deficient?
I've reported a sample of 8, but I do have additional samples that meet this criteria that I would say fall in the 10 to 12 range total so far for the audits conducted this year.
I see. And how many audits total did you conduct that this 10 or 12 people fell out?
Do we have Sandy Sutcliffe on the phone?
And just for the record, our audit is going to be ongoing. So we're just trying to increase our numbers. So this is kind of just the beginning of it, which is why we're bringing it to your attention now.
Where I'm going with this is that if the number is small and it's possible to send these people an email saying, hey, we audited you, you didn't pass this many, you didn't do this amount of CE, we'll give you an extra month, get it done quick before you fall into violation. If the number is small, I think that could be done. If the number is large and it's a huge problem, then I agree with Mr. Leyba. We may have to give it a little bit more cushion and provide more information on a more consistent basis.
But Mr. Solari, you would suggest that if it were to be a small amount, that we would just say you have a certain amount of time to become compliant? Just give them,
just give them a little extra time, but just send them an email saying, hey, buddy, get it together quick.
Like you had the right amount of CEs credits, but you did not do the 3 hours required.
Our audit indicates you did not complete 3 hours of opiate as required by whatever. Since this is new, we're going to give you an extra month. Please hurry up and get it done and submit your paperwork.
Yeah.
And I do think that there's a couple of points here. So I think there are some cases where the CEs could have been classified wrong. It's my understanding that ACPE did not add a specific opioid designation until after our requirement was in place. So there is a chance that somebody could have done a CE that is classified wrong. So perhaps there's even individuals that could show proof that some of the CE that they did were opioid related. I also noticed that there was one here for law. We did remove our law requirement, so I don't think that that's necessarily something we need to necessarily go after, but I would be in favor of your approach, Mr. Solari, to give individuals the chance to come in compliance, especially given that these are new requirements.
And for the record, Lori, so these were audits that were done at the 2019 renewal. So we kind of went backwards. And so staff, and we discussed this with the attorneys as well, but because at that time the law CE was required, that's why she's bringing it up, is because at that time that they signed their application, their renewal application, they stated that they had done them. So that's why it's being brought to you.
Good afternoon, this is Sandy. Just to let you know, in regards to the opioid CE, if we can't tell directly from the title of the CE program that it reflects opioid, we do ask the licensee to provide us additional information. And we have started a list of those CE that will meet that requirement as an ongoing process. So we don't just take the again, the title of the CE and determine that they don't meet that opioid requirement.
Thank you, Sandy. I appreciate that.
May I just make a comment? When we decided to go with the opiate law, there's always a lot of gray areas and a lot of vague things that we have to work out as time goes on. At this point, other than the title, I just want some clarification as I don't know what's required. I know that if it says opiate or addiction or diversion in the title, it probably passes. But as a pharmacist or as a technician, if I'm going through the list of CEs available to me on some website and trying to decide, is there a better way? Educate me. Is there a number change with the ACPE? Help me with that, please.
There aren't any numbers out there that I'm aware of right now. And it isn't just opioid that applies to that. Tobacco cessation of CE would count. alcohol abuse types of CE would count, again, because it isn't just opioid that was addressed with that continuing education. So what we usually ask for is for them to provide us either a syllabus of the CE that they took, some kind of extenuating, definition, so we can see what is entailed in that CE, rather, like I said, just within the title.
And to piggyback off of Sandy, like we reach out to these individuals. Melanie does a great help to do this. And when we reach out to them, we do extensive work on our own. Like Sandy and I reached out to the pharmacist letter to get more information on a couple of the CEs that appeared to be the person was claiming is the opioid related or substance use related or addiction related. And so we don't just, take it and move on. We do look into things significantly.
But there is a topic designator for pain management, which is the ending code is 08 now.
The statute that we have specifically addresses, it gives you a wide range. It says opioid related, substance use related, or addiction related.
Okay. I would certainly, I could use more education, and I'm on the board and I have access to this data. Maybe others, I'm sure there's others out there who could use more clarification on the kind of things they need to do. And I don't know if we can post something in some kind of a Q&A on the board website that further clarifies for our licensees what they need to do or what's acceptable and what's not.
We do already have that as an FAQ on our website.
There is one?
Yeah, there is.
Okay.
But I'm not disagreeing with you. I think that a lot of people don't know about it unless you were heavily involved. You maybe didn't know about it. It doesn't sound like we have a huge number of these at this time. I'm not sure, is an extension an option, Seth and Jean, as far as allowing more time to be able to do the CE when the renewal was in 2019, or when we start to do the 2020 renewals?
Jean, you're on mute.
You're asking about whether to offer more time for the cycle that started in 2019 and 2020 because of the change of requirements?
Well, right now we have a couple that are 2019 renewals, and we're going to be starting our 2020 renewal. And I think Mo had made a suggestion earlier about maybe giving them more time. And right now we don't have a huge number. I mean, that would be manageable. And I guess I thought more discussion on that.
Agencies have done that, within their discretion, considering other factors. And if more time is needed, there was a change in the law, you could do that just so long as it's applied equitably to everyone.
What if you looked at it into, we're dealing with individuals here who have done at or above. If you told them you completed the right number, you didn't complete the right types, going forward, you need to complete these and you will be automatic for an audit the following year, versus board staff having to follow up with everybody and get completion of what they didn't do. I don't know. To me, we're dealing with individuals who just didn't do the right amount, the right type. They did either enough or over the amount. And I think it takes the board staff out of the picture, being the police in it. Just a thought.
I like that. Well, what adds to the confusion too is PTC does not align with what the state asks for CE. So we've tried to make that clear in the newsletter article and kind of made comments. Jody came on and made a comment in the public comment, but it just adds to the confusion for techs.
I just agree with Mr. Leyba on that. These are not people who are violators. They just don't know. And I would rather, at least for some period of time, take the educational as opposed to the disciplinary approach to them and try to direct them rather than discipline them. I think on their own, they would do the right thing if they knew.
I think so too.
Agreed.
It's going to you with what you're looking for. I think what I'm hearing, if you need a motion, we can do that. But I think maybe corresponding with the licensee and letting them know that they were deficient in one type of CE and that they may be, I think you should use the word may, have an audit the following year and what the regulation is, and then you guys move on.
That does help, Mr. President. Thank you.
Board members, did I represent that in your view of how you wanted that?
Yes.
Okay.
If I can, I'd also like to present one other scenario that we've encountered with these audits. We have identified some audits in which the licensees come very, very close to fulfilling the minimum CE requirement, but they are short 1 or 2 hours. So I'll use an example of a technician who completes 19 of 20 hours, but they fail to complete 3 hours of opioid-related CE. In this case, an argument can be made that the technician who completed 19 of 20 hours is delinquent 1 hour or possibly 3 hours, given that they did not complete the opioid CE. So we are also seeking some guidance as to how to most appropriately quantify delinquent CE with this type of scenario.
May I make a suggestion, sir?
Absolutely.
I would consider them delinquent only in the total number of hours and give them the same latitude that we're giving for the rest of the hours other than what they're delinquent. As far as the type goes, I would give them some leniency, the same as we do the others. But if they're delinquent in total number of hours, we would go right off the grid and ask them to fix it according to what the grid recommends.
And I can confirm that that's how our audits are currently handled. It's based on total hours.
I think that's a good suggestion, Mr. Solari. Okay.
Thank you. This was all I had on this topic.
Okay. 30B2.
Okay, so this is a report that you are accustomed to seeing. For the time period of August through October of this year, the top 5 violations issued by compliance officers included those related to collection receptacles, immunizations, hot and cold water, controlled substance audit, and compounding. Are there any questions?
Okay, thank you. $30B3.
This is just a general reminder that the public health emergency remains in effect and therefore waivers are still applicable.
I would imagine that you are getting a lot of calls with items that are already stated that the emergency, the declarations from the government. Is that why it's on the agenda?
It's on the agenda just as a continuation of the last agenda,
Okay.
just to keep that reminder open.
Mr. Leyba, I have one question.
Yes.
Are we getting any new questions from the public? I know we still have the field open where people can submit questions or concerns related to COVID. Are we getting anything new through there?
Lori, that's actually my last agenda item.
Okay.
We did receive a letter that
we,
was, oh, sorry.
We do have that FAQ on online, Lori, and I have not received any new submissions through that form.
Okay, that's what I was asking. Thank you, Elizabeth.
We did receive a letter from an individual who was unhappy with the COVID task force, and I think Dr. Gandhi forwarded that to everybody. Just as the emergency continues, people are not everyone is happy with what we've done, apparently. Just a comment.
Okay. Anything else before we go to 30C?
That's all I have.
Okay, thank you. Any questions, board members, for Jennifer before we move on?
Didn't we skip 30B4?
That is the last item on
Okay.
this report. Okay, so for 30B4, this agenda item was added to discuss COVID-related inquiries that board staff are receiving and to obtain your guidance regarding how to proceed with respect to these inquiries. With the COVID vaccination quickly approaching, board staff is receiving questions about whether certain vaccination practices are in compliance with regulations. So we have two scenarios to present to the board. The goal is to obtain a motion or some guidance regarding the best manner to respond to these inquiries with regulatory compliance and public health in mind. So I will briefly summarize these two inquiries. So the first inquiry involves a healthcare organization who would like to leverage their pharmacists, their pharmacy professionals, to dilute and draw up doses of COVID vaccine for drive-through vaccination clinics. These clinics are located in parking lots of healthcare facilities and entities that are not related to healthcare. So it's a mixture. R423-617 discusses temporary pharmacy facilities or mobile pharmacies. However, this rule applies to declared disaster areas and declared states of emergency, and it also includes elements that are not pertinent to a drive-through vaccination clinic. There is question as to whether R423-617 applies in this type of scenario, or if it would preclude pharmacists from participating in vaccination activities in this type of setting. That's the first scenario. I can stop here, Mr. President, or I can continue to the second.
Board members, would you like to talk about the first scenario? Or do you want to hear both?
Let's talk about it one at a time. I think that it sounds like what the intention of that item that you cited, the statute that you cited, or emergency order you cited, was for things that would happen normally in a pharmacy, which I would include immunization. So I would think that it would be allowed. And we are still in a state of emergency.
I just want to call out that the only difference here is that these are drive-through immunization pods, is what they're being called, in a parking lot.
I would point out as well that that is not, these are not only being run across the nation by pharmacists and by permits, but you've got the National Guard doing it. You have volunteers that are going to be doing it, and we're going to see more and more of it on a mass immunization scale. I think that that is something to tackle that is bigger than what we're talking about. And for to say some can do it and some can't do it, I don't know if I would support that, especially to Ms. Snare's point that the service is the service, the cognitive ability to perform the service is still the same. The controls are still the same. The asks are still the same. I think that it is something that we need to offer in our profession, not even looking at all the other professions, the ability to have easier, convenient, and safer practices in light of COVID. Now, that's my opinion. I'm not sure that we need to weigh in on it, but that practice is going to be around, and it's going to get even bigger as we scale out across all disciplines in the medical field.
I 100% agree. I think that we should not do anything that would limit it, especially in light of the pandemic right now. And there are a number of places that immunizations could be given that aren't at a pharmacy per se, that are 100% safe and the right thing to do for the public to make sure that vaccinations are publicly available. So I would not want to see any limitation.
Okay, thank you. Let's hear the other scenario that you're getting questions on.
Sure. The second inquiry involves a healthcare organization who would like to leverage its retail pharmacies to receive, store, reconstitute, and deliver COVID vaccinations to clinics. The clinics would then administer the vaccination to patients. The clinics do not have the equipment to ensure proper storage of the vaccine, but the retail pharmacies do. The retail pharmacies and the clinics are in close proximity and belong to the same healthcare organization. So there is question as to whether this type of partnership is allowed, and if so, is a special agreement required?
feel like we've done something like this before when it's a closed system. For example, I think we've allowed one place to store drugs for the entire company to kind of order from. And I don't see that as being different. As it was a closed system, it's like if Banner allowed one pharmacy to be kind of their storage, and they've ordered from the other place. I think we've allowed that. I think it seems similar to me.
So let me clarify something if I can here. I just want to make sure I understand. So we're talking about a non-patient specific order going out to another entity that is not permitted by the Arizona Board of Pharmacy, but does have the authority to deliver to the end user.
Correct. That's
So-
permitted.
Okay, so in that regard, a licensed professional would be ordering and responsible to administer through their authoritative board, so to speak. Where I would question is there is a 5% rule of total dispensing before it becomes a manufacturer permit needed, I believe, and wholesale, thank you. That would be more of the issue in my opinion than do we have the oversight on the individuals who are about to give the vaccination? Because if you're dropping them off to somebody who has the ability to order and you're under the 5% rule, I do believe you have to think in good faith that they're going to do the right thing. Board members, I'll turn it over to you.
I do have concerns related to the storage conditions. So if they're not able to store the vaccines at the appropriate temperature, the other facility I would have concerns with that. The other part is I don't know that we can fully weigh in on this because I don't know that with the federal and state control of the vaccine, if you're able to transfer ownership of it, I don't know that an organization would have the ability to do that. I don't know that we can weigh in fully.
If I can add one point of clarification, it is my understanding that the retail pharmacy would be making multiple deliveries a day to the clinic for scheduled vaccination time.
May I ask a question?
Absolutely.
Analogy to the 503A, 503B pharmacies in hospitals or would it violate any rules to make a product to compound basically something ahead of time for a non-specific patient without having those kind of licenses? I don't know. I'm just trying to think.
No, that's where I was going, and that's why I came up with the 5% rule. But this would be literally dispensing the product, and then it could be reconstituted on site. I go back to if they are operating under those guidelines and they're handing it off to somebody who has the ability to order and give the vaccination. If are we talking about vaccines in this point? We are.
Yeah.
So if they have the ability to order and give the vaccine at that point, they should be performing on the regulation of that board that they're under. Lori, I understand your point as well, but you could say the same thing about medications that are ordered to an office under the 5% rule. Once you dispense those to the appropriate prescriber, you don't know the conditions that are going to take place there. And that goes on today. If you know something, then it's different. If you know it's not right, then you shouldn't do it.
I just think the storage conditions are so so unique with the COVID vaccine in particular. That's what just piques my interest with it.
Very much so. Very much so.
I just want to make sure I understand real quick. So, for example, Cigna, I'm just going to use my company. We have facilities where there's a pharmacy and the doctor's office is literally across the hall. This pharmacy would store this, is the scenario you're saying. They would store the vaccine, and then when the PCP is ready to give it or their office is ready to get it, they would deliver right across the hall. Is that the scenario that we're talking about?
This sounds very similar to what we're talking about.
Especially if she's been approached that it would be multiple deliveries a day, because once you dilute it, there's amount of time that it is stable.
Just because I've been in that type of system, it seems to make sense to me, but I don't know some of the ramifications. So.
Just want to share with the board members about the storage of the vaccines. From what I learned from the State Department of Public Health, the Pfizer product is the only vaccine that requires ultra low freezer. Everything else you can safely store them in the regular freezer.
Dr. Dang, I can confirm with this scenario that the Pfizer product was mentioned.
Yep.
Well, I'm not sure where we go on this one, knowing the variables involved here. I do think there are concerns, but I think we're in a special situation here with this. And I do think that if the pharmacy is playing by the rules and there is an order tied to it, this one is very confusing because to somebody's point that was made, I'm not sure you can transfer the product. I think the product in Arizona needs to be recorded at the site that it was received, and that's how the ordering will be monitored, and they'll know if you need a second dose from that, and the state will know as well. So I'm not prepared to move on this, but I think it's something to talk about and maybe watch. And if we do need to get together before the next board meeting, I think that might be something we would do. Board members?
Do we need to look at having another task force meeting to address some of these questions? I'm getting some additional questions from members out in the public. I don't know if they've come through related to like licensing questions and those kinds of things. I know that there's a lot of pharmacy positions open, both technicians and pharmacists alike, related to COVID vaccination and hiring. I know that we accepted the NABP passport and that had ended, but it's my understanding that that should be starting back up. So I'm not sure if there are any other topics that we need to look at reconvening or discussing further.
I wouldn't say we need another task force. I think the one that we have could continue, but board members?
That's what I mean in a meeting. I don't know if there's enough for a meeting for it or if that was my intention. I'm sorry if I said that wrong.
It might be helpful just because the questions are coming in, and then in addition, the vaccine is going to be coming out soon. So I'm guessing we're going to get more and more of those. So maybe that would be helpful.
It's going to get more complicated when we get to phase 2 and phase 3. The University of Arizona is going to be storing with the special freezers for the Pima County Health Department, 50,000 doses that are supposed to arrive sometime before mid-January. And the question is, from these freezers, they go out to the pods. And what you're all talking about is important for us too. I mean, just, who's keeping track of what's going on? We're keeping, the inventory information, but the pharmacy piece is not there. So it would be very important to help us out because that's what's going to happen. The university is going to be doing the storing because we've bought and have the special facility to store. The Pima County Health Department does not, but they're going to be receiving the 50,000 doses and storing it here at the university. And the question is, where does it go from the storage? Back to the county and into the pods or straight out to the pods?
I think what we will do is, Ms. Walmsley, you chaired that, if I remember, it was Ms. Nara, you, the task force. I would ask that you work with Ms. Kunavong to recall the task force and answer some of the frequently asked questions that come out, and we continue. And then there, board members, your thoughts on that?
That sounds good. I almost wonder, we had made suggestions to the governor's office. This might be one that we might want to weigh in on before the vaccine. I mean, try to stay ahead of it. I don't know if that's even possible at this point, but.
No, vaccine should be hitting either next week or the following week for the first group of the nursing home vaccines.
Sooner the better, I guess.
And that's the only reason why I bring it up is I want to make sure that there's an outlet for the public to ask questions and those kinds of things and for us to act quickly like we did in the past. That's my only point, because I think that there's going to be a lot more questions more frequently again.
Okay, so would you like a motion? Do we need to do that to schedule a task force meeting before the next meeting, or is that something that you guys can just work together and do?
President, we can figure that out.
Okay, all right. Thank you. Good discussion. Does that conclude your Deputy Director report?
Yes, it does, Mr. President. Thank you.
30C, CSPMP Director report.
Hi there, can you all hear me okay?
Yes, we can, thank you.
Thank you, Mr. President. Thank you for having me this afternoon. And hello to our new board members, Mr. Goodman, Ms. Leyhan. Wanted to share with you just a little bit about our work with the PMP. And for the most part, anytime I give a report, you're going to hear a couple common themes, and you're going to hear about our work with our integration of the PMP with electronic health records and pharmacy software systems. And you're also going to hear about measuring compliance, because statutes say that pharmacies need to report into the prescription monitoring program daily, and pharmacists need to be using the prescription monitoring program when dispensing certain drugs. So those topics are always going to be things that will encompass my report. I thought I would just kind of cover a little bit of the work that we've been doing throughout 2020 and give you a recap that will help you moving forward. So the first piece is whenever we're going to talk about compliance, is the requirement on the dispensers of controlled substance to report daily into the CSPMP. And this year, our staff, we closely looked at our data to see if pharmacies were indeed submitting daily into the PMP. And we started this in April. And at that time, we started communicating with pharmacies that weren't reporting in daily. And we took the approach of an educational approach where we would, let them know that it's not, the data is not coming in. And sometimes it was an IT issue. Sometimes it was a little confusion about if they needed to report in daily or weekly. And for the most part, we got most pharmacies on track and compliant. Unfortunately, though, there were a few pharmacies that even with constant outreach, we never heard back from them. And we reached out by way of email, we reached out by way of phone, and we just didn't make headways. So I just wanted to give you the recap of what our work was, what we did leading up to then, and then next board meeting, you will see a few pharmacies on the agenda that aren't reporting appropriately to the PMP. I can stop there if there's any questions about reporting into the PMP. And then the next piece is I'm going to go into a little bit about compliance with checking the PMP.
So Mr. Scavarla, thank you for that. These are pharmacies that you've reached out to by email and phone, and the phone was a valid line and they still didn't return your messaging or your calls?
Yes,
okay.
Sir.
And you said there are a handful of pharmacies. What is a handful, or what was the term you used? How many are there?
Well, I started with 4 of them that I'm working on. It is a little labor intensive, but I would say there's probably another 5 that we probably need to also bring in front next time if I've made no more progress.
Okay.
And these are pharmacies that have not reported in a year.
Okay, so this is past a technological problem that they're trying their best to figure out. This is a failure to report.
1 year. Yes,
okay.
Sir.
Thank you.
May I ask a question?
Oh. Go ahead, Mo.
Mr. Scavarla, we've had pharmacies come in front of us that said they are a pharmacy, but they don't actually dispense, so there's nothing for them to report. Are these pharmacies that fall into that category, or are these actual dispensing pharmacies?
Yeah, you know what the statute says is if you have an active DEA license and you have an active permit, you need to report daily, no matter what you tell us you are. What the statute reads is active DEA, active permit. So if you don't want to dispense controlled substances, or if you don't want to report into the PMP, then you'd have to give up your DEA number.
Thank you.
And this is reporting, not checking, right?
That is, yeah. We're just talking reporting right now.
Okay.
Any other questions on that? And you know what I will give you a good summary of when we made phone calls, when we send emails, and I'll make sure that we have that in the board book appropriately for you.
Thank you.
So the second area, and Ms. Walmsley, measuring the use of the PMP. What our statute says there in ARS 362606, before a pharmacist dispenses or before a pharmacy technician or pharmacy intern of a remote dispensing site pharmacy dispenses a Schedule II controlled substance, a dispenser shall obtain a patient utilization report regarding the patient for the preceding 12 months. And at the beginning of each new course of treatment. That statement in itself is a tough one. It isn't crazy clear. One thing that is clear is, it's the dispensation of a Schedule II controlled substance. That's what pharmacists are required to check on, and they must do it. They must pull that patient utilization report, which is the fancy way of saying checking the PMP. And they must go back 12 months at the beginning of each new course of treatment. Each new course of treatment's a little tricky. How we define that is not the easiest. So I'm just kind of preparing you guys for that right now. What I've been doing on my end is just trying to get data for us, try to see where we stand today. So our software allows us to drill down on any filled prescription to see if there is a CSPMP query, but it doesn't allow us to run a report on all pharmacies at once to identify those that are not using it appropriately. In other words, like there is no aggregate report to identify the most non-compliant. It becomes more of, we got a situation on hand. We look at that prescription number. We look at that doctor, we look at that pharmacist. We can see if we have a query there or not. But there is no way to just make a all-encompassing huge report to look and see what pharmacy's doing the best, what pharmacy's doing the worst. Is certain retailers doing better or worse than others? It is a case by case thing. So I'll stop there for a minute too, because I have a feeling there might be a question or two there also.
So, Mr. Scavarlo, thank you. How does that work with the integration? So I know many large pharmacy organizations, hospitals, and community pharmacies alike have the integration that is done automatically through their software system into the DUR, those kinds of things. How does that work with the individual? I want to make sure that, we've encouraged that behavior since it really has increased the utilization and the facilitation of the process in pharmacies. I want to make sure that we're giving people the quote appropriate credit where it's due.
Yeah, great question. What we use in Arizona is referred to as Aware. And Aware, you would get credit for the lookup whenever you, in the pharmacy, click the button that, you with integration, and that's part of my next piece of my talk, but when you're integrated, you have a button right in your own software system, and that button knows that you have patient Doug Skavarlov, and when you click that button, it'll take you to Doug Skavarlov's PMP report. So when you click that button, your pharmacist would get credit for a PMP lookup at that point. Now, I bring up that we use Aware because there are some corporations that have bought like a super enhanced version, which is referred to as NARCS Care. And NARCS Care, when you use NARCS Care and you click that button, to get credit, you still need to click into the patient report. So it's a two-step piece. That's not, NARCS Care is not something Arizona provides everyone. This is something those retailers have bought in addition for their own purposes. I hope that answered your question.
Yeah, I think we just need to be sure that we're not getting too, I don't know how I think this one is a little less straightforward, I guess, at least in my opinion, because NARCS Care probably is actually a superior system. Granted, it's not something that we provide to our licensees. I just want to make sure that we're not getting, going to be too punitive when we look at this, and that we take in consideration the fact that there are a lot more nuances when we look at the what's actually occurring with that versus simply not reporting data into the PMP. To me, that's cut and dry. Either they're doing it or they're not doing it. How the other is being used, I think, is a little bit more subject to interpretation.
Yeah, I couldn't agree more with your comments. Any other questions about that piece? So again, I'm in the infancy of looking at this, and what we've done is we've asked our compliance officers to pull some prescriptions whenever they do a site visit, and whenever they're doing the compliance visit, they're basically sending my team some prescription numbers to C2 on some Schedule 2 medications. We're doing the work on the back end to see if there are queries there. How we're going to define new course of treatment, I think is something that we should talk about. But what I'm doing right now is just saying, hey, out of 5 prescriptions, are pharmacies looking at the PMP or not? And I'm going to present that type of data to you guys during the next meeting. And then we can kind of go from there, and you guys can guide me on where we may want to go next. And to your point, Ms. Walmsley, maybe that's a task force meeting. Maybe that's, I don't know. But, I think you need data before you could do anything. So that's what I'm working on for you. So Ms. Walmsley brought up integration, and that was a great segue for me. And I think it's really important for our new to really know what we call integration and what we're doing. Today, the federal government's really focused on interoperability in health IT. That is like majorly at the top of all focuses. And the CSPMP's way of, kind of that interoperability in health IT is the CSP integration with electronic health records or pharmacy software systems. And for those of you that know about it, it makes the use of the PMP incredibly easy versus the way it was 5 years ago. It saves time, it's in workflow, and the healthcare practitioners can do what they need to do and not spend all their time trying to remember to their password and when to log in and all that good stuff. So the statewide integration project is what we have, and we receive funding through ADHS to help make that happen. And that statewide integration allows any pharmacist and any doctor to become integrated with the PMP. Now, to do that, you have to, your own vendor needs to integrate. So, we basically your vendor has a component of it. And all that's really happening is our vendor Apris builds an API, which we call Gateway, and that API allows for a connection with your own software system. And it makes that, again, where you can pull up your patient. And when you have your patient pulled up and you click a button, it takes you right to their PMP report. And again, what's the most important piece of it? The most important piece is it saves time for the healthcare practitioner. So, I like to highlight what our accomplishments are at this point. And at this point, we have 50 EHR vendors that have integrated with the CSPMP, which has allowed 419 healthcare entities to integrate, to be able to use an integrated product. And out of those 419 healthcare entities, that equals 24,000 prescribers that have access to the gateway. 6 of our largest pharmacy chains have integrated, as well as many non-chain pharmacies and hospital pharmacies too. And at this point, there are 50 healthcare entities in the process of integrating. And when they finish that integration process, it's going to add another 1,000 healthcare providers that will be able to access the PMP through an integrated product. I kind of teed up our work with integration because we just finished integrating the Veteran Health Administration, and that is a huge win. I think that for the longest time, the VHA and the private sector, there were gaps. And the gap was that, you couldn't always see the prescriptions that a patient was getting at the VHA that Walgreens was filling, and vice versa. And I'm sorry, Lori, it has nothing to do with Walgreens. So I think the better way to say it is your retail pharmacy, and the retail pharmacy couldn't see what the patient was getting at the VHA. And then the patient was double dipping, going one doctor at the VHA, going to the retail pharmacy, and getting prescription from another doctor. So the VHA started reporting into state PDMPs. So that was step 1. Step 2 is the VHA providers are now required to look at the state PDMPs. So now that they're being required at the federal level, look at the state PDMP that they're in, and not just the state that they're in, they have to query all states. What we're seeing is the desire to want to do it the easiest way possible. And the easiest way possible is to be integrated. So we started working on that back in January, and through many meetings with our vendor and with the VHA leadership out of DC. We just finished that integration. They haven't went live yet, but they are ready to. So the ball's in their court at this point. I wanted to shout out that win because my team worked really hard on that. So I'm going to stop there. That's all I really have to say, but maybe there's questions on integration too. If so, I'd be glad to field them.
Thank you, Mr. Scavarla. Board members? Okay, good work, Mr. Scavarla and your team. Thank you. Keep it up.
Thank you, Mr. President.
Before I move on to tab 31, is there any other items, Jennifer, that you know that I need to go back to? I think we're okay. I just want to check with you. I think we went back and we hit what we needed to. So with that, we okay? With that, we'll go to tab 31, discussion of items to be placed on future agenda.
I have a question, and if we don't have an answer, then I would like it to be put on a future agenda.
Okay.
It's regarding PICS and how many pharmacies they're able to be over. If we have a clear rule on that and how much time is supposed to be spent in each location, or just time sufficient at each location, I think maybe some type of discussion about that if we don't have a clear rule.
Ms. Nair, I do not believe that there is a rule on that number and how much time is designated.
I'm pretty sure I saw in the board book that a PIC was in 3 different states. It was all the same person. And I just didn't know. That was one question that had come up. But I've just been asked that question myself and I don't have a great answer.
Kristen, you said, sorry, Dr. Gandhi.
Ms. Nair, why don't we agendize it for a future discussion? Right now, there is no restriction on how many they can be a PIC of, nor number of hours that they have to be at a facility.
Mr. President?
Yes.
Okay, so I would like to, for the next meeting, I would like the board to discuss about the, discuss on the topic of how Dr. Gandhi and his board staff review the applications for micro hospital. The reason I'm bringing this up is because more and more, we've seen more and more applications for micro hospitals submitted to the board for approval. And many of them do not meet the minimum 500 square feet in the hospital setting according to all rules and regs. And Dr. Gandhi and his staff has been reviewing the application, have been doing the preliminary reviewing of the application for these micro hospitals. My suggestion is instead of having these micro hospitals submit the deviation request and appear in front of the board, can Dr. Gandhi and his staff make the decision based on the fact that if the micro hospital doesn't do any IV compounding, no sterile compounding, and only has only licensed for maybe 20 beds or less, I think we should give Dr. Gandhi and his staff the permission to approve the application without having these people attending the board meeting and ask us for the deviation request. Just because when they show up at the board meeting, they practically give us the exact same answers over and over and over again. I just think it's a waste of the board's time when we can utilize that time for something else.
Thank you, Mr. Ding. Kim, you're on mute.
A question about what you're asking. You're saying that they should approve even though it's smaller than what we say in the guidelines?
Yes, so if they, on the application, if they open up a micro hospital and on the application, they make it very clear that they do not, the facility is not involved in doing any IV compounding, no sterile compounding. If that's the case, and limited number of hours, not 24/7 pharmacy, if that's the case, and if they only serve 10 patients in the inpatient setting, there is typically for the past years, we have always granted them the approval anyway. And by
I agree with you.
right now, when they come in front of us, we ask this exact same set of questions and they would provide us the exact same set of answers. To me, it becomes, initially it was interesting, but then over the years, it has become like a routine.
Let's do this, team. Let's put it on the agenda. Let's not get into a discussion about it since it's not on the agenda. It has been on there before, to Mrs. Snare's point, but maybe we can revisit that. There are some strong opinions in the past, as you recall.
I would like it to be in the vein of looking at whether or not we should change the rules, which I thought was the resolution that we had the last time. Because I agree, I think our rules are just outdated with regards to this topic.
Okay, we'll place that on the agenda.
Mr. Leyba, I have one additional topic I'd like to bring up. Based on our conversation today related to the deviation from conscious pharmacy, I'd like for us to agendize to look at the long-term care rules at some point in time later. I think they brought up a very valid point that there are 40 states that allow for members of the nursing staff to fill these types of devices, those kinds of things. I think it at least deserves a discussion. Perhaps our rules are a little bit outdated. While we couldn't approve their request during this meeting, I do think it's worth taking a deeper look into.
Okay. Any other requests? Okay, we will be looking at election of board member positions at the next meeting as well. So something for you to think about. With that, before I close on and move to call to the public, I'll give staff and legal counsel one more time for me to be redirected. If not, I will move to call to the public and ask Mr. Curtis to prepare for that call to the public for the public members to be able to communicate with us. Dr. Gandhi? Okay, we will go to tab 31, tab 32, call to the public.
President Leyba, we have nobody who is called in.
I think you're muted, Joe.
Naturally, right?
Now we can't adjourn.
Yeah. Yes. All right. Thank you so much, everybody. Appreciate your participation today. Very productive last 2 days of conversation, and I do appreciate that. Looking forward to seeing you at the next meeting, and be safe out there, everybody. And again, thank you.